Good morning, ladies and gentlemen. Welcome to the American Enterprise Institute. I'm Naomi Schaefer-Riley, a senior fellow here specializing in the field of child welfare. AEI, as many of you know, is committed to finding solutions to lifting up the most vulnerable members of our society, and children who have been abused and neglected certainly deserve our serious attention. But understanding which children need the intervention of government in their lives to protect them is a fraught task. We have strong legal and cultural traditions in this country of ensuring that parents are free to raise children according to their religious and moral beliefs and their best judgment. Anytime that we tread on those rights, it must be done with good reason and with great care. Throughout American history, the strength of parents' rights has waxed and waned, but I think it is safe to say that in recent years, the cry for greater weight to be given to parents' rights has reached a kind of peak. And those voices are coming from across the political spectrum. Certainly, the pandemic and the lockdowns have grown the desire for more parental control in education among many Americans, even those who were heretofore uninterested in politics. In the medical field, a loss of trust in public health authorities has also created more debate around medical decisions by parents, from vaccines to gender transition procedures. At the same time, the field of child welfare has seen the growth of voices asking the government to step back, arguing that agencies not only suffer from systemic bias, but also that they are simply punishing parents for conditions of poverty. And yet, there are hundreds of thousands of children in this country who are abused and neglected each year. They are suffering from a variety of maltreatment: physical abuse, sexual abuse, torture, medical neglect. At least 2,000 children die of maltreatment each year, most of them under the age of 3. That's more than the number who die of cancer, and it's around the same number who die of gun violence. How do we balance the protection of those children with the rights of parents to raise children in the way they see fit? These issues are not strictly partisan. Self-described Republicans and Democrats, conservatives, progressives, strongly disagree on the substance of these questions. I was struck by a moment a little over a year ago during a Republican primary debate when Megyn Kelly asked New Jersey Governor Chris Christie why he did not favor a ban on gender transition surgery for minors. The former New Jersey governor answered with this: "We are out there saying that we should empower parents in education. I agree. We should empower parents to be teaching the values that they believe in their homes without the government telling them what those values should be. And yet we want to take other parental rights away? I'm sorry. As a father of 4, I believe there is no one who loves my children more than me. Every once in a while, parents are going to make decisions we disagree with, but the minute you take those rights away from parents, you don't know what rights are going to be taken away next." Many in the audience that night were probably dumbfounded. There are similar contradictions on the left side of the aisle. Does the party that generally favors more government intervention and support now find the government hopelessly flawed and biased? Recently, none other than Al Sharpton appeared beside a family in New York suing the city for not intervening to remove a 4-year-old child who subsequently died of starvation when his parents had a fully stocked refrigerator but had turned it to face the wall so the children couldn't access it. The rallying cry of parents' rights has gained popularity since the pandemic, and as its use has spread, its definition, I think, has grown murkier. As activists begin to push new federal legislation and even a constitutional amendment on the subject, it's worth revisiting what's truly at stake in the parents' rights debate. I'm thrilled to present 3 panels this morning, one on the legal issues, one on the medical field, and one on the policies and practices of child welfare agencies, though there will probably be some discussion on all 3 panels of the other topics as well. I think all 3 panels today are bipartisan, but the sides may shake out in ways that will surprise you. I want to thank James Phillips and the Wheatley Institute at Brigham Young University for co-sponsoring this event today. In fact, this whole event was James's idea, so anything that goes wrong, you can blame him. You'll hear more from James in a few minutes on our first panel. So with that, I'm going to turn it over to my AEI colleague, Adam White, for our first panel.
James, no pressure now. Yeah. Well, welcome everybody, and I just want to echo Naomi's greetings. So grateful to all of you who are here today and everybody who's watching online either now or at a later time. Looking forward to the questions and the conversation. Our conversation started last week, one of the usual pre-panel prep calls, and in the course of thinking through this morning's conversation, somebody, I can't remember if it was Elizabeth or Marcy, pointed out that 2025 is the 100th anniversary year, the centennial, of the famous Supreme Court case of Pierce versus Society of Sisters, one of the early cases in which the Supreme Court declared a broad right of parents to oversee and control to great extent the education of their children. And there's a famous line in that decision where the court says, quote, "The child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations." My guess is that in a conversation like the ones we're having today, practically everybody could agree with that statement at a very high level of generality. Of course, as we get to particulars, both in the life within a family and the broader life of a political community, it becomes much, much harder to pin down exactly what that means in practice. And so I'm very grateful to be joined today by four experts who are going to have a wide range of thoughts on the broad question of the rights of parents, the rights of children, and the power of the state, and the responsibilities of parents and the state. Let me introduce the speakers very, very briefly in the order that they'll speak. We'll hear first from Professor Elizabeth Kirk. She's an assistant professor of law at the Catholic University of America, where she also co-directs the law school's Center for Law and the Human Person. Then we'll hear from Marcy Hamilton. She's the founder and CEO of Child USA, a nonprofit think tank focused on improving the laws and policies that protect children against neglect and abuse. She's also a professor of practice at the University of Pennsylvania and an experienced Supreme Court litigator. She successfully argued the famous case of City of Bernie versus Flores. Then we'll hear from Walter Olson. Walter is a senior fellow at the Cato Institute's Robert A. Levy Center for Constitutional Studies. He writes widely on constitutional law and constitutional culture. And it's always nice to welcome my friend Walter back to AEI, where he was previously a researcher and an editor. And last, we'll hear from James Phillips, the aforementioned James Phillips, who Naomi will hold responsible for the success or failure of this event today, as you mentioned. He's an associate professor at BYU, where he also directs the BYU Wheatley Center's Constitutional Government Initiative. He previously practiced constitutional law with the Beckett Fund. So again, thanks to all of you for joining us. And Elizabeth, why don't you go first?
Okay. All right. Thank you to Naomi for the invitation, and to Abby and all the staff of AEI for their hospitality and hosting us here and online. So Naomi sort of deftly lays out this thought-provoking angle on the parental rights debate, which is the strange bedfellows it has attracted with conservatives and progressives together, relying on parental rights to resist governmental intrusion into the family. In my brief remarks, I just want to make 2 points briefly. First, that the legal landscape of parental rights and the counterintuitive ideological perspectives brought to bear on it involves more than the context that we'll largely focus on today of child welfare and healthcare and education. So a few examples just to make this point that the field is broader. The title of this panel is Parental Rights and the Constitution, so it's appropriate to begin by pointing out that as the cases percolating through the courts demonstrate, 100 years after Pierce v. Society of Sisters, the Supreme Court's failure to address and resolve the constitutional foundation for the protection of parental rights, the applicable test or standard of review to aid in line drawing, and the scope of parental rights in concrete cases, especially as found in our nation's history and tradition, has generated admittedly great fodder for legal scholars, but confusion throughout the law, whether relating to custody, visitation, education, or medical decision-making. The court's rhetorical language, which Adam cited for us, throughout the last century provides lofty language, right, to support parental claims But parental rights claims from both sides of the aisle often fail, whether it's parental objection to offensive curricular materials or programs in public schools on the one hand, or parental objection to state bans on gender transition treatment. The state, whether through its parens patriae power to protect children or its police power to regulate the medical profession or provide for an educated citizenry, usually wins. Also, those advocating for stronger constitutional protection of parental rights in decision-making through heightened judicial scrutiny must think about the impact on other areas of law that, like child welfare, do not cut neatly across ideological lines. So, for example, in the area of juvenile justice, do the requirements of due process, which the court has already held applies in some sense to minors, combined with a robust notion of parental rights, require more parental involvement or even parental culpability in the juvenile justice system? What about in custody disputes? It is axiomatic that a custodial parent is entitled to a hearing on his or her fitness before their custodial rights are impaired. And yet, given no-fault divorce and the rise of non-marital childbearing, every day in every state throughout the country, courts adjudicate questions of physical and legal custody and visitation often without any allegation or evidence of parental unfitness, meaning that one parent who might oppose the breakdown of the marital relationship and has done nothing to demonstrate parental unfitness may have his or her parental rights curtailed. And to do so, courts universally employ the best interest of the child standard, which is notoriously subjective and susceptible to politicization. So, would a vigorous parental rights doctrine call for greater restraint by the state in custody disputes between fit parents, as it already exercises in the context of disputes in intact families? Or would it call for a more objective standard than best interest of the child? What about in areas that we think of like that we cast as children's rights? So what would be the impact of a robust parental rights doctrine in areas where legislatures or courts have already granted minors, especially adolescents, autonomy, such as under the mature minor doctrine or in the context of reproductive decision-making? What about fathers' rights? Would a more robust parental rights doctrine require greater parity between fathers' and mothers' rights in the context, such as in the context of abortion or adoption? The list could go on, child labor, et cetera. There's many different contexts. And all of this is to say that the ways in which parental rights claims arise are myriad and complex and do not lend themselves easily to one legal test or predictable outcome. Constitutions and courts aren't well suited to addressing so many matters at a high level of generality as so much of our substantive due process jurisprudence already makes clear. Even legislatures can't make everyone happy, and in so many of these areas, especially child welfare in schools, personnel really is policy. So that's my first point, that it's complicated and that both sides need to be careful about what they wish for. A second point is that the rhetoric or even constitutional invocation of parental rights is not going to get us very far if we can't talk about what is genuinely good for the child. And this is admittedly more and more difficult because of deep fractures in our polity about notions of the good. Some scholars characterize the recent conservative emphasis on parental rights as purely rhetorical, necessary because addressing the underlying view directly would be politically unsuccessful. So to give a couple of examples, one scholar says, quote, "Movement conservatives do not want to argue against racial justice, so they make a parental rights argument against schools teaching critical race theory." Others describe the reliance on parental rights as, quote, "retrenchment by diversion." That is, an attempt to reverse the achievements of equality-focused movements by concealing that motive with the more politically palatable rhetoric of parental rights. This seems like an unfair volley against conservatives, and not just because it presumes conservatives are mostly motivated by bigotry or hate. Both sides, to be fair, invoke rights claims to push back against those in power, depending on which side of the razor's edge of majoritarian politics we happen to fall. But it is a cautionary tale for both conservatives and progressives. Rights ought not be mere proxies for policy preferments or secret agendas. It might be better or clearer, if our jurisprudence allowed for it, not to speak about rights at all. Rather, we can speak of a moral principle which even the state must respect. In the case of parent and child, we can speak of a relationship, which is something more than a bundle of rights, and by virtue of that relationship, we can speak of the grave duties parents uniquely owe their children and the freedom they must enjoy in order to discharge those particular duties well. Except at the margins, those on both sides of the aisle likely agree that the state has a role to intervene when parents fail and a child will be harmed. But that only works well in our polity if we agree about what sorts of harms or risk of harm justify such a supervention of authority. It only works when we agree about what parental rights are for, and that is some objective good of the child. Detached from the good of the human person, including those goods pursued by parents in discharge of their concrete and particular obligations toward their children, rights simply are rhetorical devices in a power struggle, whether between parent and state, parent and child, etc. And it doesn't matter, I think, if we shift our lens, such as from parental rights to children's rights. We have to have some method or measure by which some authority determines the content of the right if it is not to devolve into sheer autonomy and power struggle. So I'll close by saying I think without a restored national discourse through which we can tackle hard questions together in light of shared criteria, we may eventually find ourselves strange bedfellows, but at the end of the evening, we sleep in separate bedrooms. Thank you.
That's great. Thanks. Great. And next we'll hear from Marcy Hamilton.
Good morning.
Morning.
I'd like to thank AEI and especially Naomi for organizing this. I promised Naomi that I would start by saying that I think this conference is misnamed. There is no such thing as parental rights without talking about children's rights. That's both true in the Constitution, the two Ps, right? Pierce v. Society of Sisters, which does not have quite the broad interpretation we've heard, but does give parents the power to decide on an educational setting within the context of requiring education, period. But Prince v. Massachusetts, in which the Supreme Court clearly said in their own words that parents may make martyrs of themselves, but they may not make martyrs of their children in the face of child labor laws. So that there's no question that children have rights as persons under the Constitution. As someone who has now worked for over 20 years fighting first clergy sex abuse, but now institution-based sex abuse across the country, there is no clearer fact than that adults prefer and protect adults. It is uncanny how fast you can have a conversation about children that turns to the interests of the adults almost immediately. So where can we turn to figure out what this baseline would be that Elizabeth was alluding to? It's my view in my scholarship that Joel Feinberg, who is a philosopher, stated it best. Children have a right to an open future. That means parents and the society together have an obligation to deliver a child to age 18 not having been abused, not having been medically neglected, and not having been denied vaccines, and also educated. At a minimum, the day they're after 18, they can decide to have no medical care again. They can decide never to be educated again. They can't decide to abuse others. But let's go into the realm of facts instead of politics. I'm really not interested in politics in this. I'm interested in the protection of children. One of my first posts on clergy sex abuse, these many years ago, I said that the Catholic Church was not doing the right thing. Bill Donahue of the Catholic League immediately emailed me, and he said, "You are anti-Catholic." And I said, "My cradle-to-grave husband, Catholic, would disagree with you, but even more importantly, I'm not anti-Catholic. I am deeply anti-child abuse." And he responded, as he should have, touché. So let's talk about the facts with respect to children not being abused or abused, educated, not educated, medically treated. When we fail children in these three arenas, we know that on the abuse side, 30 to 34% of child sex abuse comes from within the family. That's a good third comes from within the family. This is the last frontier. While we see headlines about institutions, and we are making very good progress toward holding institutions accountable, parents continue to be behind the curtain, rarely prosecuted, and children continue to be abused. 1 in 5 girls and 1 in 13 boys, according to science, will be sexually abused by the time they are 18. At one point, it was 1 in 4 and 1 in 6, so we've made some modest improvements, but it is about 14% of our children are going to be sexually abused. What does that mean for the larger society? That means that the larger society suffers, because abuse results in trauma that results in PTSD, depression, substance abuse, inability to thrive in relationships, and worse, suicide. The cost to a victim, let's talk AEI's monetary terms, cost to a victim is a minimum of $300,000 over the course of their lives. If they are sexually abused, that's a combination of medical, psychological problems combined with lack of earning potential. If you look at ACEs, the childhood impact science, you see that you have lasting reductions in employment and in employment success over the course of their lives. 13 to 19% lower earning for children who've been sexually abused than those who have not. I understood at the opening that Naomi was speaking broadly about philosophical and religious support. And that we should support parental rights because of religion and morals. I think we need to be very careful about that in the child sexual abuse arena. There are no more adamant opponents to children in that arena than the religious groups. The lobbyists against the laws to protect children are coming from the Catholic bishops. They are coming from the Mormons. They are coming from the Southern Baptists in particular at this point. So let's be realistic. Let's not be Pollyannas about religion. As a law and religion scholar, I can tell you that child sex abuse continues to be buried in all arenas of society, and adding to parental rights with respect to child sex abuse harms society generally. With respect to child vaccines, we already have done an experiment in learning what mandates mean. What does a mandate without a religious exception and without a philosophical objection do for your society? Well, Mississippi and West Virginia until now can tell you. It means they have the lowest disease rates in the entire United States. Neither Mississippi nor West Virginia had any exceptions to childhood vaccine mandates, and they had eliminated, to a large extent, the major childhood diseases. They are now being pushed hard for exemptions. There's an erroneous decision in Mississippi that there's a First Amendment right to an exemption for vaccines. The cost to society of not providing mandated routine vaccines for childhood diseases is huge. From 1994 to 23, the best statistics are that we save $780 billion in direct costs and $2.9 trillion in societal cost due to vaccinated children. That means children who not only were vaccinated, but also did not infect their pregnant mothers or their elderly grandparents, who are most at risk of dying from the childhood diseases. With respect to vaccine preventable illnesses, vaccines are a public health priority because once a child has these diseases, they are more likely to have long-term adult health care problems. They're more likely to have diminished capacity, and they are more likely to have lack of economic productivity. You can talk to anybody who's had polio. You can talk to the people who have died now of measles from unnecessary outbreaks from people unnecessarily not vaccinated. But let me add to that. Medical neglect is a serious problem. And there are states right now, not a lot, but there are states right now that permit faith healing exceptions. In the state of South Dakota, where faith healing organizations have flocked because they no longer found Washington State and Oregon as comfortable as they had liked, you have groups that have more infants in their cemeteries than adults because they don't believe in any medical care. So what that means is that a child whose life can be saved with a penicillin shot is not saved for religious purposes. Now, I guess it's 2 years ago, one of the Republicans in the state, and this is just who is saying it, I couldn't care less about politics. Republicans stood up and said, faith-filled Republicans stood up and said, the reason that these children are dying is because God has called them to heaven. I'd like to say as a Presbyterian that my God does not call infants up to heaven when they can be medically treated with ordinary medical treatment. So one of the things you have to think about when you bandy around this concept of parental rights is how much harm are you willing to tolerate, right? Both to the child, to the family, and then to the community. With respect to education, a lack of a minimal education results in lower lifetime earnings, higher unemployment, and economic instability. It is a threat not just to democracy, which is the verbiage of the last election. It is a threat to the economy when children are not educated to the point by the age of 18 where they can contribute. So let me just close quickly by saying that there are entrenched children's rights that are buried in this obsessive talk about parental rights. And those rights include an entrenched due process right against abuse. It was not illegal to sexually abuse a child until after it was illegal to abuse an animal. The Society for the Prevention of Cruelty to Animals was founded almost a decade earlier than the first Society for the Prevention of Cruelty to Children. So we are very slow with respect to children's rights, but we now have 50 states in the federal government that outlaw sex assault, sex abuse, child abuse, and letting your child die. Those are so entrenched that the due process rights are clear, and that children have a right to life, to quote the 14th Amendment. Second, with respect to medicine, Jacobs v. Massachusetts approved of the concept that vaccines and the state interest in vaccines can trump the interest of an individual not to be vaccinated. The court was quite clear on the importance in that case of eliminating smallpox, but polio, et cetera, follows that line. In Prince v. Massachusetts, as I said previously, the court said that no parent has the right to make a martyr, whether philosophical or religious, of their child, which is to say, no parent has the right, if the state has passed a law requiring medical treatment and vaccines, to deny that child that treatment. And finally, with respect to the right to education, Tinker sets up a right of the child to speak in the school environment. We have more recent theories involving in loco parentis, But the key here is that the harm to society from a lack of educating children up to age 18 is so well documented and so extreme that we really must look at it as a children's right and not as a parent's right, as in some states has been proposed, to pull their child out of school at 13 after they take a quiz and put them into labor for the rest of their lives. Thank you.
Thanks, Marcy. Thanks, Marcy. Next, we'll hear from Walter.
Thank you, Adam. Thank you, Naomi, and to everyone at AEI. And let me recommend Naomi's article in National Affairs this past summer, which I think well lays out some of the conflicts and tensions in this area. She invited me here to, I think, give a robust libertarian case for parents' rights, which I will proceed to do. Even though when it comes to practical policy on the ground, Naomi and I very often come out in pretty much the same place. And you'll see this again and again, which is that first principles often take a rather winding path to policy recommendations. Well, yes, the world has changed on parental rights. Yes, they are stronger than they used to be. And I'm going to argue that that's a very good thing. When I was growing up, homeschooling was illegal most places. I'm not just talking that they made it bureaucratically difficult, I'm talking that they just didn't allow it at all. Since roughly the 1980s, it has been legal. As recently as 2008, a California appeals court said, well, maybe it's has to be legal, but parents should not be allowed to do it unless they have someone with teacher credentials as judged by the state come in and do it for them. That was overturned. But it was fairly recently illegal, and also within living memory, because I've talked to a lot of people, you could lose custody of your kids for being gay. You could lose custody of your kids for a marijuana conviction. Lots and lots of things that were later legalized and where we recognized that parents were perfectly capable could result in CPS arriving and taking your kids away. And we're lucky. Society has made progress that it doesn't do these things anymore. And in doing so, I think there is a lot to be said for what Governor Christie said. And he wasn't the first, of course. I remember in the debates about 200 years ago about whether or not the English king should be viewed as a father to his people. Macaulay, one of my favorite classical liberal writers, put it almost exactly the same way. He said, we might expect a monarch to be like a parent if a monarch knew his offspring as well as a parent knows his or her child and loved the subject as much as the parent loves his or her child. That's not going to happen ever, which is why you can't expect the government to behave like a wise parent. The government is for other purposes. It can do some other things well. It can't be a parent well. I visited orphanages, and I can say, even if they hire good people, the government can't be a parent well. So behind the growth of parents' rights has been this very diverse ideological coalition. Often libertarians find themselves on the same side as conventional American conservatives, and I think there's a reason for that, which I'll get to in a minute. But you know, it isn't just religion. As we go back through the cases that are monuments in parents' rights, yes, there's Pierce versus Society of Sisters. Yes, there's Wisconsin v. Yoder. But a couple of years before Pierce, there was Meyer versus Nebraska. We don't hear as much about that, and yet that was the first in the line. Nebraska banned instruction in the German language. And just as Oregon, in Pierce versus Society of Sisters, was at under the influence of the Ku Klux Klan and others that were trying to drive a minority religion out of the state by hook or by crook. So Nebraska, in the heat of World War I anti-German sentiment, had passed what I take the liberty of calling a bigoted law, since I think there's nothing wrong with being instructed in German if that's what your community speaks. And what's interesting here is that Meyer versus Nebraska not only recognized an unenumerated right, which meant that along with Pierce versus Society of Sisters, libertarians love it forever because we love unenumerated rights, and the recognition that sometimes courts need to and can endorse unenumerated rights, but also it did so without a religious component. Obviously, in Wisconsin versus Yoder, it got explicit, and they said that they were applying religious liberty doctrines to the right of the parent to educate. It was certainly not far from the surface in Pierce versus Society of Sisters, but in Meyer versus Nebraska, it stood alone. This was not a religious issue. This was a question of whether or not the state could substitute for the parent's judgment on upbringing, and the court ruled that it could not, and that line of cases continues in good health today. Again, I'm glad that it does. I'm glad that the area is ruled off limits for the government. Now, the other struggles happened one by one, and let me get on now to a point that I mentioned, which is that there is a reason why a lot of these things took a long time to litigate and restored to parents not some new right that they had never had before, but restored to them a right that would never have been questioned until relatively modern times. Rights of homeschooling, rights of instruction, and the like. And that was because the progressive movement had invested in the government an enormous amount of confidence that it could act in loco parentis. It was the progressive movement that brought in a big, big way the idea that the government could hire experts who could determine what the best interests of the child were in education and a dozen other fields of life. If the family were living in a sloppy, disorganized way, government housing inspectors could come in and tell them either to shape up or lose their children, as has happened in countries like Sweden that went a few jumps more. I think Sweden has pulled back. But for a while in Sweden, if you were too sloppy, your healthy kids could be taken away. And there was nothing where it wasn't felt that the government was more competent than parents. Well, those were progressive ideas. They were not original founding American ideas. And so it's not surprising that both conservatives and libertarians saw through them pretty quickly. They did not trust the expertise of the government. And let me say that here you're getting to the ultimate, I think, libertarian position, which is not somehow imagining that parents can't violate children's rights. Obviously they can. Children have individual rights like everyone else. Parents can commit crimes. They can probably commit torts, whether or not you call them torts. But the question is the competence of the government. And if you agree with me that the government just isn't very smart about this. Even if it makes the right decision, it may take 5 years to do so while the child goes through multiple placements. If you agree that the parent is more likely in the overwhelming number of cases to know and to love their child in a way that the government can't, then come along with me to the parental rights side. You'll find that most of the public is there too. Thank you.
Thanks, Walter. And finally, we'll hear from James. While he's making his way to the podium, I just want to say, in addition to folks in the audience here being able to ask questions later, folks who are watching online on the live stream can do so as well. If you go to the event page on our website, it'll have the ways in which you can submit questions by email or by Twitter. James?
All right. Well, I'm grateful to be here. I just want to talk about some high-level concepts and then some constitutional doctrines. We're obviously all dealing with a line-drawing problem here in a complicated, difficult area. And I'm going to mostly set aside the divorce custody context where you might have some dueling parental rights issues. Obviously, I'm sure you all had the same reaction I did to Marcy's stats, that they're horrifying. But I'd also say that the overwhelming majority of parents love their children and treat them well. So I think there's two parts to the line drawing problem. First, identifying when there is a conflict between parental rights and children's rights and interests. And then number two, what to do when there is such a conflict. And for me, a Venn diagram is helpful. So if you think of one circle representing parental rights and one circle representing children's rights, If there's perfect overlap, then we'd say that's a scenario where parental rights always support and never conflict with children's rights. And if there's no overlap, we'd say there's always a conflict. And I think most people would reject those two extremes. Obviously, there are times when there are conflicts, right? As we've heard today, there are times when parental rights can be used against the best interests of the child. But the other extreme is also problematic because often parental rights actually support children's rights. That's because parents almost always know their children better than anyone else. Parents usually are more invested in their children and interested in their welfare than anyone else. Parents have the primary duty for the care of the child, and the child-parent relationship is generally the most important relationship a child has. There are also some societal reasons to not necessarily view parental rights and child's rights always in conflict. And that is protecting parental rights is a way to protect the family, which I would argue is the most fundamental unit of society and the most important of those mediating institutions or little platoons, depending on whether you like Tocqueville or Burke, upon which our society and our constitutional system depends upon, but which our society and constitution do not create. So knowing where the line is not drawn, perfect overlap, no overlap, is a little bit helpful, but it doesn't necessarily tell us where the line should be drawn. So how do we recognize when there's a conflict? Well, one option is when a child says so or does something that indicates there's a conflict by expressing a desire for something other than what his or her parents want. That's probably, though, I would argue, neither necessary or sufficient. Children don't always grasp what's in their best interests, and that can cut both ways. A child may agree with their parents, but the child may be wrong. It may not be in their best interest what the parents are advocating. But a child could also disagree with their parents and also be wrong. And sometimes children really just don't have an opinion. The only other option then, of course, is the state. The state decides when there's a conflict. I think we have to be careful there about having the bar too low for a state actor to declare a conflict, though where the bar is may be situationally dependent. Maybe where the bar should be for child welfare versus education versus medical care should differ depending on the consequences of perhaps getting that wrong. So fleshing out when the state can declare a conflict and act on it is, of course, the rub. And we're all looking for that Goldilocks middle that is just right. Now, I want to say two things about types of conflicts. One way to think of it is one type of conflict is when the state actor thinks there's one and the parent learns that the state actor deems there's a conflict. But the other would be when the parent doesn't even know that the state actor is determined that there's a conflict and acted on it. We see this latter often in the educational context where school officials make decisions that may potentially infringe on parental rights without the parent even knowing that that's going on. And this latter conflict where parents are kept in the dark over this judgment by the state that there's a conflict and a need to act seems problematic, deeply problematic to me, except in emergencies or for temporary periods of time when that may be necessary. Now, we don't really have a panel on education, so let me just say one quick point on that, and then I want to move into some constitutional doctrines. Walter talked about some changes in parental rights in that context with homeschooling and the like, and obviously courts have recognized that parents can take their kids out of school and put them in private schools, or they can homeschool their kids if they don't like the public school curriculum. I'm not sure that's fully solved the issues with parental rights in education, just for a very practical reason that 82% of the children in this country are in public schools, and most people can't afford a private school or afford to have one parent quit their job and homeschool the kids. So I'm not sure that that's a financially viable solution to tell parents that that they have those options. It might also raise an unconstitutional conditions doctrine. But of course, on the other hand, we can't have parents dictating every jot and tittle of the educational curriculum. So again, the line drawing problem. So on the constitutional doctrine front, right now, as was talked about already, We have substantive due process is seen as the source of parental rights under the Constitution, stemming from the 14th Amendment. And as Elizabeth pointed out, there's a lot of lack of clarity and a certain degree of confusion over that. A fundamental right under substantive due process normally triggers something called strict scrutiny, which is the highest degree of analysis and the most protective of rights. And yet we don't generally, it's usually strict in theory, but not strict in fact in a lot of the parental rights cases. Perhaps that is because parental rights are a little bit different than the other types of rights that have been recognized under substantive due process. Those other rights tend to go to individual autonomy, but parental rights, you have the child's rights and interests sometimes juxtaposed in that scenario. So perhaps that's why courts have struggled with this, or at least applied it in a way differently than we usually see with fundamental rights under substantive due process. So it might be helpful for the court to provide some clarity on that. Is a substantive due process parental right? Is it the same as other substantive due process fundamental rights? Or if not, how should we be thinking about it? Some people dissatisfied with substantive due process have proposed some alternatives. So some originalists, Justice Thomas being a leading example of this, have said, substantive due process is bunk constitutionally, and instead we should be doing this under the Privileges or Immunities Clause. That's where substantive rights are incorporated in the 14th Amendment. I'm not sure how that would play out because unlike due process, which attaches to persons have a right to due process, privileges or immunities attach to citizenship. So it's the privileges or immunities of citizenship. It's not clear that parental rights are a privilege or immunity of citizenship. Some people have argued that they're pre-political in that they exist, they're not created by the state, and they're certainly not enumerated in the Constitution. And so it seems like a little bit of a stretch to put parental rights there given the citizenship angle. Michael Ferris has argued that we should get rid of substantive due process for parental rights and just go with procedural due process. And of course, procedural due process is also an aspect of parental rights doctrine, but he would have it all be done under procedural due process. The one possible limitation or challenge to that is procedural due process doesn't apply to general legislation. So if the state legislature passes some law that you think infringes parental rights, you generally can't bring a procedural due process challenge to that. You had all the procedure that you're going to get, the Supreme Court has decided, if the legislature has just done their job and you had got a chance to vote for them. So not sure that that's necessarily going to solve the problem. Melissa Moskela has analogized, I don't think she was necessarily making the argument that we should import legal doctrine, but she's analogized the international community's relationship with a sovereign nation to the parental rights context of kind of parents and the state. And she notes that only under the most dire of circumstances will the international community go into a sovereign nation and take over because of the way things are going. I'm not sure there's clear standards there, though, in the international community for such things, other than perhaps a vote of the UN or a desire of some countries to do that. So I'm not sure that's going to necessarily solve the line drawing problem. So I guess I would just leave with the thought that I briefly mentioned before. Again, I think the family is a fundamental unit of society, and parental rights and children's rights are often not in conflict, but we have to figure out what to do in those scenarios where they are. And I would agree with Marcy that instances like abuse are heinous and should be. We should not have a society where that occurs, and we should make sure that the law recognizes that. But the devil's in the details, right? And a family that gets too regulated is unable to function properly, and our society and our Constitution depends on families functioning properly. Thank you.
Well, that's great. Each of the initial presentations have given me a few things I'd like to ask about. But before I jump in with my own questions, if there's anything that any of the panelists want to react to immediately, anything that jumped out that you'd like to sort of put on the table right away, I'm happy to start with that.
I would just
Sure, Marcy.
very briefly say to Walter, there are organizations that have begun that are in response to failure to educate and homeschooling, outlining the harms that have been done in the homeschooling context and the failure to educate. One of the leaders is the Amish Heritage Foundation, which looks at Wisconsin v. Yoder as one of the most child-harming Supreme Court decisions in history. So these are very smart people who educated themselves after they left a community having not been educated. And the statistics on the harm done in some of the homeschooling situations are pretty serious. So just...
In the absence of a right, the actual political resolution of the issue will also depend on things like whether the public education lobby is strong or not. That's one of the reasons I trust the idea of individual rights more than I do states where the teachers union could pretty easily get their bill passed. Again,
well, as usual, you've adverted to adults, and I'm talking about children.
Okay. Let me mention while we are on that trope that periodically people who suffered neglect or abuse as children or had terrible childhoods are quizzed about whether or not they think they should have been taken out of the house. And overwhelmingly, as I understand it, the answer is, no, I don't think I should be taken out, even though my mother was an alcoholic, even though my father had serious mental illness, because she's my mom. Something to think about.
Unbelievable. That is not the science.
So let me start with at a very high level of generality. A couple of statements jumped out at me. Let me start with a couple of statements from Elizabeth and Walter. Elizabeth, in your sort of opening remarks, you said, and I'll get the specifics wrong, but something along the lines of, we can't really grapple with these issues of parental rights without directly grappling with what's best for the child. You put it better than I did, but that all these debates around rights and powers, they really do sort of revolve around a central question about what's actually in the best interests of children specifically. Walter, in your opening remarks, you said, and again, I'll get it slightly wrong, but you said, so much of this really reflects one's view of the competence of government. That whether we're on, say, at a general level, the side of the parents or the side of government or civic institutions that are trying to go past the parents to protect the kids, so much of it comes down to your underlying sense of the competence of government relative to maybe the competence of the parents in deciding what's good for the children. I would love to hear further thoughts on that, others' reactions to those two statements, that these really, the debates around the law are just echoes or downstream of your view of either government or a specific sense of child welfare. Elizabeth, did I do justice to the way you put the point originally?
Yeah, no, I mean, I think I would say that, to kind of pick up on what Marcy said, which is to say, like, when speaking about parental rights, we shouldn't be speaking about the interests of adults, right? We should be thinking, and that's why I think sometimes the rights language is not super helpful, because we're not talking about the power of parents, right? We're talking about the needed freedom or authority of parents to discharge their obligations to their child well. And so I agree with Marcy in the sense that, like, to the extent we're talking about parental rights without thinking about what they're for, which is for the care and the education and the upbringing and the formation and the love of their particular children, then we're sort of missing the boat entirely. But I do think to sort of pitch it as in this rights language, like parents' rights versus children's rights, and that we're automatically putting ourselves in a place where they're sort of naturally in tension with each other, which I think is probably the wrong place to start. Could they be in tension with each other? Sure, but like that's not the right place to start. And then I guess just to finish that thought, just to say that I do think, though, where the line drawing is difficult, or contested, what constitutes harm, et cetera, what you're going to see is conservatives or libertarians are going to peel off and like, well, if I'm going to err, I'm going to err on the side of trusting the family or the parents. And progressives are going to lean on the side of, well, I'm going to lean on the side of trusting the state or the experts, et cetera. And I think politically that's what you're going to see.
Yeah, Walter, let's draw you out, and then I'll ask the others for responses.
In Elizabeth's remarks, she made a point which I heartily agree with, which is that the best interest of the child standard, so-called standing alone, is maximally vague and also, I would say, maximally empowering to the decision maker, whether it be a judge or an agency that gets to decide at first cut what the best interest of the child is. All evidence has to be considered, everyone has to testify on everything that possibly could influence the child's welfare, and then you put huge amounts of authority in the decision maker. Now this, to me, is exactly what has gone wrong in areas from contested custody cases to some of the more liberal standards for taking kids out of the home. You don't want that because of the uncertainty, because of the peril into which it places everyone's rights. What is the opposite of that peril? Well, it is things like presumptions, like the primary caretaker presumption for custody, or the standard mentioned in Naomi's paper somewhere, I think, which is that to take a child out of the home, there has to be a serious and well-demonstrated risk of severe harm, probably physical, to the child, and that lesser instances of harms, like I would argue lesser instances of harms through speech on the internet, aren't reason for the government to take away people's and I insist on using the word rights, because I think the word rights works better. People don't want their relationship to their child to be a matter of endless administrative balancing. They want to think, we belong to each other. And although that has to be ruptured occasionally because of circumstances, we shouldn't want people to continually contemplate that rupture.
Now, Walter, I am actually going to get back to the question later of this term rights. Marcy, what do you make of this, the suggestions that so much what we're discussing now in terms of rights is really downstream of one sense of what's what's good for a child generally, or also is a government competent in actually discerning and implementing the sense of what's best for a child?
Well, the science about the protection of children is getting better every day. It's extraordinary, the number of scientists that are working on this, that we're finding out what children need to be protected from. So I do think that legislation can be very effective. And what I find is working on child sex abuse legislation in Congress is it's bipartisan. They're all interested, but you know what they're interested in the most is the science. They want to know, how does this affect a child? Why should we do this? And the same is true in the states. But I think the rights moniker is absolutely necessary with respect to the child. There was a time not that long ago when fathers owned their children as property, literal property for the purpose of labor. And so enter the Industrial Revolution, and children are working and dying in factories, et cetera. That is what triggered the child labor laws and the compulsory education laws. So those two are the backstop against a parental rights that did never consider the best interests of the child and instead considered the child as a source of labor. Now, I'm never going to disagree with people love their children. Yeah, I love my 2 children. But that's not the point. That's not at all the point. The point is the child in a scenario where they can be protected from harm? And how in the United States do you protect yourself from harm? It's called the law. And if you don't have legal protection as a child being harmed, you can't be pulled out of the horrendous home. And I'm not going to give you the details now. People can talk to me afterwards. There are horrific homes in the United States where children are dying and being tortured. So don't tell me about how the government is so dangerous that we should prefer the adults. Unless you're talking about children's rights up against parents' rights, they won't be protected adequately, in my view.
Yeah. James, any thoughts on this?
I'm happy to turn it open to the
Well,
audience.
not quite yet, though. I've got a couple more. Marcy, I want to follow up with you because I was thinking through in your presentation as last answer on questions of abuse. I'll put it bluntly. I'm Catholic myself, and thinking of abuse of children, the abuse within the church of children is horrific and demoralizing. Thinking through neglect becomes more challenging, right? The story, you told the story about the parents who turned the refrigerator around. That's horrific. Of course, neglect at some point becomes a bit more difficult to draw lines on, right? And I'd use like a cartoonish example. Like at some point, is it neglectful to get my kids more interested, more focused on music or sports than STEM? There might be an answer to that. I don't know. I guess it depends on how we're measuring it. But it becomes very hard to define neglect with specificity once we get beyond like the really obvious cases. How should we think about that term? Less so abuse, but more neglect.
Right. Fair question. But the standard for neglect tends to be the child is going to be either permanently disabled or die in the medical neglect context, at least, right?
Okay.
So the cult in Denver that believed only in feeding babies lettuce, so all of their babies died, that's neglect, right? There's a debate right now in the United States, which is unfortunately veering off its scientific baseline, but neglect with respect to vaccines, I view the failure to vaccinate, except in medical exceptions, as a neglect. The mandates view it as neglect. There are those who are now saying no, that the parents' rights should take them out of that. But it seems to me we just have to keep circling back. If you want to figure out where the law should be, it should be where there's harm to the child, very serious harm. And then other than that, parents get a lot of latitude. But we also have a lot of responsibilities to educate parents, because a lot of parents don't know how to protect their kids from the internet. They don't even know how to protect their kids in sports. So there's a big educational need. If we're going to talk about parents' rights, it needs to be informed parents, and so that's.
See, I guess then my question was off base to begin with, because I didn't realize you were talking just specifically and primarily in terms of medical neglect, not say economic neglect.
Medical and food neglect.
And educational also.
And educational neglect as well. Yeah, I mean, the states have compulsory education laws, which were undercut by Yoder. But Yoder was about a mythical religious entity, right? It relented in the footnote. Warren put that the Amish never break the law. They are a beautiful people that have never broken the law. That's just flat out false. And so the Yoder's problematic, but neglect is a serious problem with respect to education as measured by the impact on the larger economy.
Yeah. Can I ask about now the term rights? We alluded to that earlier, because I was thinking through much of the presentation how when we're talking about parental rights, I did start to wonder whether that's the right term to begin with. No offense to the title of the panel, but when we're talking concretely about the stuff of parents' rights, we seem to be talking about power, or James's term earlier, sovereignty, or responsibilities. Walter, I have to say, it doesn't quite strike me as the classical sense of rights, because we are talking about the relationship between parents and children, the authority, first and foremost, the authority of parents over children. Let me push back, I guess, a little bit on the right sense. Why don't we talk about this in terms of parental powers or sovereignty or responsibilities?
Well, sometimes we do, and sometimes it makes sense to talk in those terms. I don't mean to be too light, but when Elizabeth said that the consequence of bad law would be that parenthood would turn into a sheer power struggle, I could only remember trying to raise a 3-year-old, and how it could get into any more of a sheer power struggle than that. But to be more serious, rights I think, direct us toward the minority of situations in which there is a legal move to curtail the parent's ordinary relationship to the child, whether it be by taking the child away or perhaps by some sorts of injunctions. That's where rights come in. And obviously, a lot of other situations that are important are not better analyzed in terms of rights. And I would say we've touched several times on questions of dissident parents in schools, parents who disapprove of curriculum, parents who disapprove of vaccine requirements. And I would say that any school system that I chose for my kid had better have a vaccine requirement. But I understand that the whole thing about compulsory public education is that it submerges the wishes of a minority, which doesn't get its way. Is that rights? Well, no, it's not always rights. The fundamental right when it comes to education is that of exit. The parents ought to be protected and sometimes helped in their ability to organize counter-institutional schooling that better reflects their values. But actually, I come out in a boringly liberal position on a lot of the questions of whether public schools have to change because conservative parents want something different out of them. No, they don't have to change.
Yeah. Walter, since you, in your remarks, alluded to children's rights in addition, can you just sketch out, just in a few sentences, obviously can't do justice to it, but what the children's rights are in your framework of parental rights?
Well, they turn up in a couple of different ways. When the child gets old enough, and we talked about what used to be called emancipation, and now I believe there's a more modern term about more mature children, then libertarians traditionally are actually pretty enthusiastic about making sure that there are strong emancipation rights, in part recognizing that parents will often not see as well what the child wants and needs, and the child needs that freedom. But obviously there are children young enough for whom that's not important. I would say that to some extent children's rights represent the legal shadow cast by the fact that parents can commit crimes, including neglect, but also crimes of violence against their kid. The children's right, even though the child will not necessarily be proceeding in court as a prosecutor or something, the child's rights were violated when the parents committed that crime.
Elizabeth?
Well, I just wanted to jump in on this question of rights. I think invoking parental rights never helped me with my three-year-old, so that's it's probably not very effective there. But I do think that I'm not at all trying to say that we should abandon rights as a kind of legal construct or whatever, or as a reality in our constitutional jurisprudence. I'm just pressing back a little. The rights talk conversation is obviously much broader than this panel. I'm just trying to push back in this political discourse, because I think when we do talk about parental rights, we can tend to lose sight of what they're for, which is the child. And so I think speaking of it in terms of that relationship is important, and that's the emphasis I meant to make.
Yeah, James, anything to add on this?
No, I really like Elizabeth's connection. I think too often in rights discourse throughout our any kind of right, we lose sight of the fact that there's a duty that is attached with the right, and so not losing sight of the duties is important.
So one last question for me before we open it up to the audience. But I wouldn't be doing my job as a member of the department here on social, cultural, and constitutional studies to ask at least one institutional question. We've talked broadly about the state throughout this conversation, and from time to time we've focused on judges or agencies or legislatures. Just very broadly, I'd ask everybody, how much of these legal questions really turns on whether the governmental decision maker is a judge or an agency or a legislature? Obviously, it depends widely on the subject, the issue at hand. But are we really talking broadly about the state? Or are we talking about particular kinds of decision makers who are better or worse at resolving these issues? Walter?
Thanks. And this question fascinates me too, because when I hear, for example, about the problems of reliance on experts, I like to counter, don't assume that you're not going to have that problem with any of the possible decision makers. Experts can lead government administrative agencies astray, but of course experts appear in court proceedings where they lead the decisions astray in very similar ways. And if there's no government on the scene, then experts can have an even worse effect on parents by going on TV, giving them the worst advice conceivable about the problem that their kid is facing. So yes, they face similar things. Libertarians traditionally have tons of confidence in the courts, the common law courts, to handle things rather than agencies. I'm not going to get into why I'm a bit of a dissenter and don't always think that courts do such a great job, but I will point out that in the 19th century history of the development of child welfare institutions, it started out with the courts doing a lot of it, because the courts looked over the welfare of wards, who had no legal parent and things like that. And the courts were drawn more and more deeply into things like appointing inspectorates, roving bunches of people who looked very much like executive branch officials, but answered to the courts, to the point where eventually, I believe the British government said, look, this is an administrative agency, let's just put it in the executive branch. Something to think about.
Anybody else? James?
I've been somewhat convinced by Yuval Levin's arguments in his new book, American Covenant, that we should probably be running to the legislatures first on these issues, because legislatures can deal with complex issues, or at least hopefully can, and competing interests in a way that courts can't. Usually it's kind of a zero-sum game in court. You win or you lose. It's hard to create nuanced solutions. And so while there is obviously a role for courts, I think these difficult issues would be best to start and try to seek a legislative solution. Not everybody gets what they want. That's the whole point before running to the court.
Marcy, are these questions that lend themselves best to sort of broad legislative resolution with real specific regulations, or are these very fact-sensitive questions that it's inevitable that the power has to be somewhat delegated to judges and administrators to resolve specific cases?
Well, the legislature is much better situated to do the broad-based, survey, to do the commission, to do the task force. The courts can't do that. The truth is that the divorce courts, the custody courts, are an absolute mess right now, and that routinely children are being given to abusive fathers through the demonization of the mothers. It's something that's happening across the entire United States, and children are continuing to be abused. So I don't have a whole lot of faith in the family court system right now. But with respect to legislation, it gives me hope, because it's almost always bipartisan, and they really are focusing on children and trying to do something meaningful, and I expect that in the coming administration.
Yeah. Elizabeth?
Not to repeat, I think I largely agree that the legislature ought to be the place where these conversations happen in a robust way, and it might be why the court, including the Supreme Court, hasn't definitively decided all of this for us, because it's really not the best suited to do that. The only other thing I would add beyond what's already been said is just to say that I think conservatives, and perhaps libertarians too, have abandoned many of these institutions, whether it's child welfare or the public school system, for political reasons, or thinking they're too broken or something. And I think by creating that vacuum, right, we don't contribute to those spaces and to the way they operate. So I think that's something important to keep in mind.
Well, if anybody here has a question, raise your hand. There are 2 microphones in the room, so let's make sure they find it. The first question will be here, and then the second question will be right there.
Thank you so much, Will Estrada. And I have a question for Marcy. I want to push back on the criticism of Wisconsin versus Yoder. So the first question is, the Supreme Court took pains to say that compulsory attendance laws are important. And so that's the first question. Wanted to get your thoughts on that. But the second one is, I see Wisconsin versus Yoder as a defense of a pluralistic, diverse system of different views in our country. And so how would you square criticism of Wisconsin versus Yoder, again, the Amish, Mennonite, Old Order, after their kids were, I think, 16 or 14 in the case, they could stay home, 8th grade, with a diverse, pluralistic, big country?
There's really nothing in the decision that's talking about diversity and pluralism. The decision is really about weighing the interest of the society and democracy and a well-educated set of children up to age 18, and a religious group that said that it did not want to educate their children past 8th grade. I think they clearly made the wrong balance. What they should have said was that there is a compelling interest in democracy having educated individuals up to the end of whatever the compulsory education requirements are of the state. But the way that the opinion is written, it is a literal love letter to the Amish. It is offensive. As I said, there's a footnote, but it was written by Warren, so I'm not surprised. But the love letter includes this footnote that says that the Amish never break the law. That is an absolute outrage. As someone who lives in Philadelphia and knows exactly what's going on in Reading, let me tell you, they're just humans. They also break the law. They also are in car crashes when they should. I mean, it's a silly opinion because of its Pollyanna attitude toward religion. This notion that you can take children out at age 14 and that's good for society has turned out to be false, as the Amish Heritage Foundation is working on every single day. So that's why I think it's problematic. I also think it's problematic because it's been interpreted well beyond its facts, letting many religious organizations fail to educate their children in ways that have been detrimental to the children and the society.
Next question.
Jennifer Jacobs. Question for maybe the constitutional scholars. The Fourth Amendment with regard to social workers has been largely ignored in nearly every state that's passed laws essentially assuming there's a social worker exemption to the Fourth Amendment in terms of invasion of property, person, and papers. Up until 2022, when the Pennsylvania Supreme Court ruled that that is not an appropriate exemption, but there hasn't really been anything else at a Supreme Court level. Any thoughts from constitutional scholars or others up there on the Fourth Amendment as applied to social workers violating the integrity of families?
Anybody? Walter?
Well, this is not my area, although I think the Cato Institute, with which I'm associated, might have been involved in a couple of cases, but that was other people. In general, the rights against government agents entering your property eroded a whole lot as the administrative state grew. And it may be that the challenges are more likely to succeed in areas like safety inspections for OSHA and that sort of thing, in part because you have deeper pockets of people willing to challenge it there, whereas the parents so often are in a position where they just feel they have to let the person onto their property. And yes, I watch those cases with interest. It ought to be that government is fully held to the search and seizure standards, not that they are relaxed in the name of modernization.
Though at the same time, the parents in an abusive home are not going to protect the child. And the facts do need to be known. So there needs to be a balancing here. The child sex abuse victims least likely to be able to come forward are in the family, because families both threaten those children and families want to stay together, and the state often irrationally wants to keep them together at all costs, including the child's costs. The child can't possibly have their full voice heard unless there is some kind of state intervention in those circumstances.
Follow up.
Sure.
So not disagreeing on the ideological goal of finding an abused child and rescuing them. Of course, without a warrant, there is a great possibility of state harm, and that's kind of the whole purpose of the Fourth Amendment. So in the same way that we require a warrant, except for exceptional circumstances, when going after mass murderers, rapists, pedophiles, it's unclear to me why the state or why the courts have been largely silent on why those rights would not apply to the family when great harm can come from invading the integrity of an innocent family.
Elizabeth, you were about to say something?
I don't I don't know how the court would rule, the Supreme Court would rule in that particular case with respect to the Fourth Amendment, but I only want to say that I think it's actually even more complicated than that in the sense that the entire child welfare system, from the knock at the door to the reporting, systems and how you get your name off that system if you were wrongly reported or found to have not been, to have not violated the law, et cetera. Like throughout the entire thing, I think these are questions, right, that a court addressing parental rights broadly needs to be thinking of. So
That and the underreporting of child sex abuse.
Hey,
It's massively underreported.
One last question for me to wrap things up. I mean, just in this conversation to start things today, so many of these legal issues have arisen from now famous debates over religious education, in the Meyer case, teaching of German in schools. Later, things like the church sex scandals and so on, homeschooling, and most recently, debates around the vaccination requirements and the content of public education. I guess I'll spring the question on the panelists because we didn't talk about this on the prep call, but it just occurred to me. Does anybody want to venture any guess at what the next context for these sorts of legal debates will be? Are there going to be new frontiers, new issues emerging that we should start thinking about ahead of time? The Chris Christie quote involving gender and transgender therapies, I suppose that will be big in the next 10 years. Any other sort of new contexts for these debates around the rights of children, the rights of parents, power of the state? I guess I'm kind of springing this on folks. Go ahead, Walter.
No, I mean, we will be hearing more at a later session about the whole gender change debate. And it fascinates me that not only in that, but also in other areas where culture wars are playing themselves out first as discussions about children, although not only children's welfare is at stake, is that you have both sides accusing the other of child abuse. Now, I think that excessive accusations of child abuse, are not in themselves new, but I would predict, and you already are seeing it in the more obscure areas, that in things like curriculum in schools, you are getting perilously close to both sides charging the other with child abuse. And I don't know, maybe that makes sense from the standpoint of the contestants, but the implications that taking the wrong side on a curriculum fight in your high school makes you abusive enough that there should be an investigation of you, I would just sort of say, whoa, please back off a little bit on the culture war.
Marcy, since you're on the front lines of some of these fights, what do you see sort of over the horizon?
I see the biggest warfare about to take off during the Trump administration and the rise of Christian nationalism as a war against LGBTQ, both children and parents. And so that's, we were already in a position where Title VII is now protecting employers. They're now permitted to fire people because they're gay, simply because of their religion. So now that we've reached that point, the question is how far the rest of the system will go toward dehumanizing LGBTQ and especially LGBTQ children.
James?
And trans is a tiny, tiny percent of that whole scenario.
James?
This is only partially responsive to your question. I don't know that we can fully grasp everything that may be on the horizon. I think, there may be things we're dealing with now that 10, 15 years ago we just didn't foresee. But I think a lot of the focus here is, you maybe have heard of the famous thing of, building a fence at the top of the cliff or putting an ambulance at the bottom. We're talking a lot about ambulances, I think, today. And the family has to succeed. We have to have healthy, functioning families in this country. And that includes where children, that means where children are safe and healthy. And so focusing on that fence at the top and figuring out ways to have healthy, functioning families will alleviate some of the need for these ambulances, and I think is absolutely crucial for our republic.
Elizabeth, you got the first word today. You get the last word too.
Well, I don't want to speculate on new ideas for fear of giving folks ideas about what to argue about. But I guess I would just say that I think this panel discussion really highlights something I said in my initial remarks, which is simply that I think what we at root disagree about and need as a nation to get better about talking about is what constitutes harm in the first place, right? And so it's clear we disagree about what constitutes harm, and therefore it's difficult then to draw the limiting principle and all of the legal issues that follow.
Great. Well, before we break, I just want to say we're going to take a 5-minute break in between this panel and the next panel so that things can be reset. But please join me in thanking our speakers.
Started again, if you can grab your seats. We are ready to launch our second panel. All right, everyone. Now that we have settled all of the legal issues around parents' rights, we are ready to move on to the medical sphere. The eagle-eyed among you will recognize that we do not have a single MD on this panel. And that was not by design. We actually had a doctor who was going to come, an expert from USC. Unfortunately, the wildfires have made her home the home of many of her friends, and so our thoughts are with her, but we are going to move on. But as a result, I'm going to offer just a few sort of contextual remarks about kind of the medical sphere. I am not a doctor. I do not play one on TV. But I just thought it would be helpful to have a little bit more context. So I just wanted to start by saying that medical professionals are responsible for about 13% of child maltreatment reports in this country. Nearly 40% of those reports were substantiated versus about 26% overall. Often doctors and nurses are responsible for reporting the most serious cases of physical abuse, as these children are the ones who show up in emergency rooms. They're also responsible for reporting substance exposure in newborns and other parental behaviors that might affect the long-term health of babies. Doctors are often seeing red flags when it comes to kids, but we are actually less and less likely to believe them. A recent study found that the proportion of adults reporting a lot of trust for physicians and hospitals decreased from 71% in 2020 to 40% in 2024. Among those with lower levels of trust in the medical profession were women, African Americans, people from rural areas, people with lower incomes and lower levels of education. These lower levels of trust in the medical profession can in turn impact the likelihood that parents will trust doctors to make determinations about kids' health. Can we trust doctors to diagnose child abuse, to tell us when to vaccinate our children, to diagnose or treat gender dysphoria? What does it mean that the medical establishment seems increasingly at odds with parents? Is the medical community ignoring parents' interests for the sake of protecting children, or have they overstepped their bounds? Are there dangers to children if they do defer to parents more often? So to answer some of these questions, we have 4 great panelists today. I'm going to give very brief introductions. Emma Camp is an associate editor at Reason Magazine, where she's written a number of articles about this topic. Mike Weber has spent 40 years in law enforcement with 15 years as a crimes against children investigator. Maxine Eichner is the Graham Keenan Distinguished Professor of Law at UNC Chapel Hill. And Lior Sapir is a senior fellow at the Manhattan Institute, where he's written extensively about issues related to trans. You all can access more extensive bios online, but I wanted to start by asking each of the panelists to talk about their work and where they see the rubber meeting the road on the issue of parents' rights. So we're going to start with Emma.
Well, first of all, thank you so much for having me here today. It's really exciting and wonderful to be here with so many really incredible thinkers on this topic. So to start, at Reason, I've done a little bit of reporting on child protective services abuse, and how child abuse pediatricians often get involved in many of these cases. And the sort of prevailing feeling that I get from a lot of parents who have been accused of child abuse by child abuse pediatricians who find themselves in the system is this overarching feeling of a lack of due process. There's this feeling that once an accusation of abuse has been lodged, it's nearly impossible to get it removed, even as there are plausible alternate explanations for a child's injuries. So for example, earlier this year, I did an investigative piece with a family in Georgia. They took their infant daughter to the doctor after they noticed she had some swelling in her leg. That led to the doctor recommending that they go to the hospital, where several fractures were found, and the parents were accused of abuse. Specifically, the mother was accused of abusing the child. But almost immediately, it became obvious that there was another explanation. The infant was obviously medically fragile. At one point, she was hospitalized for 6 days and needed a feeding tube after she had been removed from her parents. She continued experiencing bruising at every single foster placement she was at. But according to the state, when she had bruising with her parents, it was abuse. But when she had bruising with foster parents, it was just discoloration. She was found to have very low vitamin D, and another doctor suggested that what she actually had was neonatal rickets. She had a very large soft spot in her head that, according to some people who had handled her, it seemed a little too big for a baby as old as she was. And so the additional doctor said, well, this is probably bone issues related to neonatal rickets, but the child abuse pediatricians who saw her insisted over and over and over that it must have been abuse, that there was no explanation but abuse, and that no other possible evidence could have convinced them that this child wasn't being abused. And this is all with parents who had no past interactions with the criminal justice system. The parents had a toddler-age daughter where they found no injuries on her. If I remember correctly, at this point in the case, the CPS has dropped the case against parents, but they still have criminal charges pending. And so that's just one story among many you can find with other great investigative reporters who have written about these cases. Parents will often say things like, I feel like I can only get my kids back if I admit to abuse I didn't do. Where there's this feeling that there's a presumption of guilt almost. And so if the parent is guilty, if they definitely abuse their kids, it's obviously worse, right, to be guilty and to insist that you're innocent than to be guilty and say, you know what, I'm sorry. But then the problem with that is it doesn't really create a situation in which parents can be innocent. And there are other civil liberties issues that compound on this, one of them being the prevalence of warrantless searches. So it isn't quite the same as a criminal search warrant, but most of the time you have to get basically a warrant equivalent to search somebody's home in a CPS case. These cases are extremely common, not necessarily with child abuse pediatricians being involved, but there's a study done a couple years ago that estimated that the lifetime risk of a child being subject to a CPS investigation is as high as 1 in 3. And ProPublica did an investigation into New York City's CPS agency a while ago, and they found that in less than 0.2% of searches, the agency had actually obtained a warrant, and parents often agree to these searches out of fear, out of coercion, out of sometimes being completely lied to by the social worker that's pounding down their door. And there are plenty of good reasons why a parent wouldn't want to consent to these searches, considering it often doesn't just include looking at a home, but often the children's body, right? Children are often required to pull down their pants and lift up their shirts, and it's very understandable why a parent would not want to consent to that. There's also an issue of drug testing. A lot of times how CPS gets involved is women who are drug tested shortly before or after childbirth. But the problem is a lot of times these are kind of pee in a cup drug tests that are extremely sensitive, and so you can get false positives from over-the-counter medication, prescription drugs that are prescribed correctly, even poppy seeds. It sounds like an urban legend, but you can test positive for drugs with poppy seeds. Trust me, I've done it for a reason. And most infuriatingly, there was an article in the Marshall Project finding that women were being investigated by CPS and sometimes having their children removed when they tested positive for drugs they were given during labor. A study done in 2022 found that 91% of women given fentanyl in their epidurals tested positive for it later. And so all of this leads to this environment where there is a feeling of kind of a general lack of due process and a belief that child abuse pediatricians in particular are infallible. And you end up with a lot of cases where parents really feel as though their rights have been violated.
Okay, great, thank you. Mike?
I'll respond a little bit to Emma. Child abuse pediatricians aren't investigators. They don't investigate crimes. That's not their job. That's something I think everyone should understand. That is police's job to investigate crimes. It's CPS's job to determine if abuse has happened, where the child should be placed. And CPS doesn't make that determination. A family court judge makes that determination. And I'm going to tell you that family court judges, at least in my state of Texas, err heavily on the side of caution for the parents. Sometimes too heavily. Sometimes they put children back into abusive homes. And that's a very, very real thing. I also hear a lot of talk about concepts and about this big picture. Every single case is dependent on the evidence involved in that case, right? You can't just lump everything together and say, well, oh, this was a false allegation, so all of these are false allegations. It's not the way this works. It's not the way any criminal investigation ever works. I can tell you in my state now, And interestingly enough, I think Texas and New York are two states that have CPS are forced to read parents their rights when they go talk to them. I cannot tell you how insane that is from a police perspective. I don't have to read anyone their rights if they're not in custody. That is, the Supreme Court has ruled over and over and over. No one's ever in CPS's custody, ever. So and their right sheet in my state is a full page. It's much longer than Miranda and much more extensive. So what that has done for my criminal investigations, what I have to do now is I have to rush my suspect interview because they only have so much time before they have to contact the suspect. So it affects criminal investigations. So the things that our legislatures are doing are far-reaching. And you know, when you get into an area I'm sure we're going to get into, which is medical child abuse and Munchausen by proxy, you have a huge lack of understanding in the legal community. Probably the two dumbest communities on that are police and attorneys. And judges are attorneys. And they just do not understand the concept of how a mother could intentionally exaggerate, falsify, or induce symptoms in their child. And it's a battle that we constantly fight. And they're hard cases. They involve a lot of work. And a lot of times human nature takes over and people just decide not to do their jobs. You know, I have a quote here. This is from a defense expert on a case. And I wanted to read this. This is after the jury found this mother guilty of abusing her child and sentenced her to 20 years. Regardless of the verdict in this trial, and really regardless of whether the child's mother is guilty or not, there is a larger issue here. That is dogmatic. That is extremely frightening for individual cases. That is, you cannot be on a crusade in criminal cases. You have to look at the evidence in each and every case and make a determination from the evidence whether there is guilt or not.
Thank you. Maxine?
Thank you. Hi. I brought you a slideshow. I want to work through with you what I think is wrong with the so-called medical child abuse diagnosis, and I'll cover a little bit about why it's actually not a diagnosis, but I'm happy to take that up more in questions. So the genesis of medical child abuse came in 1977 when a British pediatrician, Roy Meadow, published 2 case studies of mothers who, it turns out, had deliberately misled doctors to get their children medical care that they knew that their children didn't need. It appears for some twisted purpose, like getting attention. In one of those cases, the mother did what we call fabricated illness, meaning she lied about her child being ill. She made her daughter look like she had symptoms of a urinary tract infection by putting her own menstrual blood in the child's urine specimen. Yes, heinous behavior. In the other case, the mother actually induced illness by feeding her child salt, and her child later died from that. Roy Meadow said this behavior could be likened to Munchausen syndrome, the psychological syndrome in which patients feigned illness to get attention and medical care from doctors, and the name Munchausen syndrome by proxy stuck. And soon doctors from both sides, on both sides of the Atlantic, started to diagnose this behavior. But 3 issues came up. First, Roy Meadow had called this Munchausen syndrome by proxy. He hadn't meant to suggest that this was a real psychological syndrome with some particular psychopathology that made the people who did this ill, mentally ill. But lots of people took it that way. It later turned out from investigation, there's no particular psychopathology associated with this behavior. Some people have depression, some people have other mental illness, others register as completely mentally healthy. So that's one issue. Second and related issue is who was going to diagnose this behavior? Was it mental health practitioners or pediatricians who come into contact with the child, but not the parent usually? And the third issue, and the issue that the Munchausen syndrome by proxy diagnosis eventually foundered on, was how to separate these really twisted parents from parents of children who were legitimately ill, often with rare illnesses that people didn't recognize. And although they're rare illnesses means they are rare, there are more than 7,000 rare illnesses. So 1 in 20 children actually has a rare illness. Ultimately, child abuse pediatricians had done a pretty poor job at separating children with legitimate medical illnesses from the twisted parents. And as you can see here, Roy Meadow turned out to be the lead candidate in this. He was stricken from the British medical rolls, not allowed to testify in trials anymore, after a mother who he'd been responsible for convicting, who had 2 children die. She was convicted for murder, which is also, let us recognize, an absolutely heinous consequence for a parent who had already had 2 children die. It turned out a geneticist was able to track that it was a genetic illness. She was released from prison, died of alcohol poisoning a few years later, her life in ruins. The question became, what do we do with the Munchausen's diagnosis going forward? The leading candidate in the US, and the suggestion that was ultimately taken up, was let's talk about this instead as medical child abuse. That suggestion came from Carol Jenny and her husband, Thomas Roessler. Carol Jenny is a child abuse pediatrician. And what she said is, let's not talk about this as Munchausen's anymore. Let's call it child abuse. And let pediatricians diagnose it because they are experts in diagnosing child abuse. And she came up with this definition. Medical child abuse is when a child receives unnecessary and harmful or potentially harmful medical care at the instigation of the caregiver. If you take a look at that definition, it does not talk about parents intentionally inducing illness in healthy children or fabricating illness in healthy children. It is a much broader and vaguer definition. And in fact, the way Jenny said it should be interpreted was even vaguer. Anything that could potentially harm a child, even if it didn't harm a child, an extra medical examination, a blood draw constituted something that was potentially harmful. So what that means is that whether a pediatrician could diagnose medical child abuse depended on, first, whether they decided that medical care was unnecessary that this child received. Recognize any medical care a child receives has been authorized by some doctor, and also whether the caregiver instigated medical care. Now, if you think about it too, parents instigate most medical care for their child. If what you mean is they take the child to the doctor, kids largely cannot get medical care unless the parents take the kid to the doctor. So this is a far broader definition. If you believe that parents have a constitutional right to direct their children's medical care, which the Supreme Court certainly believes, this should be a chilling definition for you. Nevertheless, the American Academy of Pediatrics, a few years later, accepted this as the way to, quote, diagnose this behavior going forward. As I said, if you look at this definition, this is not a legitimate medical diagnosis. This is a determination by the pediatrician that the parent is to blame. Nevertheless, pediatricians present this to judges as within their scientific authority and simply a medical diagnosis. So what does it mean about how many parents can be targeted by pediatricians? Well, Carol Jenny told us this when she sold this new concept. She went through 115 case files in which she'd been asked to look for Munchausen syndrome, and said that 33% of those files she decided there was Munchausen's. Now, this is a pretty startlingly high figure, given that the supposed rates of medical child abuse in the medical community are 1 in 50,000 kids. And the rate of children with rare diagnosis, we know, is 1 in 20 children. So for 33% of those cases to come up as positive is startling. And serious pediatricians looking to figure out that induction or fabrication behavior should be trying to pare this down. What Jenny told us is, in fact, 76% of the cases she was asked to review turned out to register as positive for medical child abuse under her new standards. Recognize that is more than twice as many parents that her new supposed diagnosis targeted. If you believe that kids should remain with parents and it is harmful to pull them out and accuse their parents of abuse, this should cause great alarm. It did not cause great alarm for Carol Jenny. In fact, she touted this new, much broader diagnosis and its ability to get to more than twice as many parents is a virtue of this new diagnosis. And we were off to the races in the United States. So where are the extra cases coming from? Carol Jenny tells us that too. Under the Munchausen syndrome by proxy diagnosis, when a child was diagnosed with a legitimate medical illness, that was taken to be a diagnosis of exclusion. It excluded the medical child abuse, the Munchausen syndrome by proxy diagnosis. But under medical child abuse, Carol Jenny said, the fact that a child has a legitimate medical diagnosis does not exclude medical child abuse. And in fact, she said, 74% of the cases that she designated as medical child abuse had legitimate medical illnesses in the children diagnosed. So the point now is medical child abuse is picking up a very different group of parents than those original parents who'd been committing this heinous fabrication or induction behavior. It is targeting parents of kids with legitimate medical illnesses. Sorry about that, wrong click. Here we go. So one thing to know is there is absolutely no reason to associate now the 3/4 of parents who are getting picked up with kids with legitimate medical illnesses with that kind of heinous behavior. I have spent the last 4 years parsing the medical literature. There is no reason to suspect that parents of sick children would be responding in some twisted way, and a lot of evidence that suggests these parents are just doing the best they can in a difficult set of circumstances, getting their kids the medical care they believe their children need. Just last slide. Pediatricians who were serious about getting it right, locating these twisted parents, and leaving alone the parents who are doing the best they can, would try to do better than they did under this original Munchausen syndrome by proxy diagnosis in terms of figuring out how to target the right parents. Child abuse pediatricians have done nothing of the sort. They rely on a process that Carol Jennings suggested, which is essentially going through a child's medical charts to see if the statement of the parents recorded about the child's history matches the medical testing, et cetera, the observations of parents. How reliable is this determination? We have no idea. Pediatricians have never tried to test its reliability. We can make some guesses, though. We know from a number of medical studies outside of the medical child abuse field, medical records are rife with errors. The average percentage of all notes with at least one significant error is 84%. When people go through medical charts, average number of significant errors per patient is almost 8. You can imagine that with children with complex medical histories, their files will be full of medical errors. And when they compare medical charts to the statements of parents and also patients in other studies, what they find is most of the time, the errors come not from the parent or the patient, they come from the medical chart themselves. But we also know from studies of what parents tell investigators and doctors outside of the medical child abuse field, parents make all kinds of mistakes in stating their children's history. There's a study that 3 weeks after mothers give birth, 20% tell doctors incorrectly whether their kid has been monitored with a fetal monitor or whether their kid experienced jaundice. Those kind of misstatements happen all the time among ordinary parents. Medical child abuse as a supposed diagnosis gives doctors the excuse then to go to a judge and pronounce the child medically abused and to have the child removed. On top of that, the diagnostic protocol for medical child abuse doesn't require that a pediatrician consult an expert in rare diseases, and many of the indicators they look for of supposed medical child abuse are in fact the same indicators that are present in complicated kids with complicated medical conditions. For example, that the child presented with symptoms that don't make sense given the supposed diagnosis that the child has received. I'll leave it there. Happy to take questions.
Okay, thank you. Lior?
Good morning, and thank you all for being here. Thanks, Naomi, for inviting me. My research and work deals with pediatric sex trait modification procedures, known popularly under the euphemism gender-affirming care, and policies related to gender transition, especially social gender transition in K through 12 schools. And in both realms, the medical and the educational, parental rights are now being invoked. In fact, they've become kind of the main show. Though, interestingly, in each one of those policy arenas, the parental rights argument is made by the other side. So on the medical side of things, it's those who want their kids, or I should say, let me be clear about that. It's those who believe that kids should be able to have access to these treatments who make the parental rights claim. And in the education context, it's those who object to schools performing social transition on kids and keeping that secret from parents who make the parental rights claim. So in the time that I have, I want to kind of briefly outline how these arguments play out and why I find the parental rights argument to be unpersuasive in the medical context and persuasive in the education context. So let me start with the medical. To anybody who's been following this issue and not exclusively through Huffington Post, there is a growing international consensus that pediatric sex trait modification procedures lack evidence for safety and effectiveness, while the risks are real. And several European countries have started to change course, have imposed either sharp restrictions in the case of Sweden and Finland, Norway, Denmark, or have banned them altogether and relegated them to clinical research trials, as in the case of the UK. Health authorities in other countries, especially France and Germany, have issued stern warnings that the evidence is highly uncertain and that the risks are very real. So there's a kind of a globe, and of course the World Health Organization a year ago came out and said the evidence is, the quote was, variable and limited for the benefits, for the safety and benefits of these procedures when done on minors. So there's a growing international consensus against these treatments. Here in the United States, of course, things are very different. The issue is highly polarized and politicized. Mainstream medical organizations, not all of them, but most of them, have come out in favor of these treatments. In September of last year, the biggest surgical association, the American Society of Plastic Surgeons, broke from that consensus and agreed essentially with the European bodies that the evidence is highly uncertain and that the risks are real. So those who appeal to consensus, those who say these treatments are good because the doctors say so, the experts say so, already run into difficulty here because the consensus is starting to shift. I think it's going to be very interesting to see those who have kind of tried to silence the debate by saying the experts have spoken. What's going to happen in a year, 2, 3 years from now when most experts are saying, no, this is bad. We should not be doing this with kids. And in fact, that has already started. We're already seeing, including in the peer-reviewed medical literature, some of the leading voices of advocates for so-called gender-affirming care starting to say, forget about evidence, forget about consensus. This is all about the autonomous right of the child to pursue what they call their embodiment goals through hormones and surgeries. So the goalposts are already shifting. These changes in Europe happened because of systematic evidence reviews, which in evidence-based medicine is the kind of the gold standard for evaluating the state of the evidence for a medical procedure. Every single systematic review of evidence to date has come back with the same conclusion. There is no credible evidence that these treatments are safe and effective. Every single one of them. So this brings me to the, one last thing to say. Dr. Hilary Cass, who of course led the multi-year investigation of the UK's Gender Identity Development Service and submitted an almost 400-page report to the NHS last year. She was interviewed at the New York Times a couple months later, and she said American doctors are woefully out of touch. There's also a consensus abroad that American doctors, specifically those who kind of preside over this area of medicine, are just off the rails. Which brings me to parental rights. I think the claim that parents, rather than, let's say, state legislatures, because so far we have over 24 states that have passed restrictions, the claim that parents should be the ones to decide whether their kids undergo these procedures, I think runs into 4 difficulties. The first is it fundamentally misconstrues the authority that parents have over their children and the professional and ethical duties of clinicians. Parents don't have a right to tell doctors what to do to their kids in medical terms. Parents have a right to choose from among the options presented to them by ethical and responsible and evidence-based clinicians. That is a key distinction. So this morning I sent a text to my friend who's a pediatrician. I said, give me a quick example of something that parents demand that you prescribe to their kids and you say no. And he said, every single day I have at least one parent come in and say, I want you to prescribe my kid antibiotics. The problem is they have a viral infection. And my friend who's a pediatrician says, no, I'm not going to do that, especially because your kid has had antibiotics several times over the course of the last year. We're going to be destroying their immune system. Or their gut health, right? So that's a good example of how a parent can demand something and the doctor says no because it's not clinically indicated and because it would be net harmful for the kid to get it. And the same is with Ritalin and Adderall. There's many examples of this, right? So parents, of course, there's a parental right to consent to treatments and to direct the medical decisions of your kid. But that right is necessarily constrained by the prior ethical and clinical duties of the physician to first do no harm. So that's the first point. The second point is that parents in this particular area of medicine are rarely given complete and accurate information. And I say that based on 4 years of being involved in this area, having reviewed many informed consent forms from gender clinics, working very closely with Jamie Reed, the whistleblower from the St. Louis Pediatric Gender Clinic, who worked there for 4 years, hearing from parents, talking to journalists who have interviewed many parents associated with particular clinics. The information that parents are given at best is incomplete, at best. And very often, what I think is the most twisted and tragic aspect of this whole thing, parents are told, sometimes in front of their kid, by the gender clinician, your kid will commit suicide if you don't sign the dotted line. That's pure emotional extortion. There is no credible evidence to suggest that kids are high risk at suicide and that, without these procedures, and that these procedures are the thing that's going to prevent them from committing suicide. In fact, gender clinicians from Europe, including Rita Kaltiala, who's kind of the leading gender clinician who brought gender-affirming care to Finland, have called American doctors out for acting irresponsibly with the suicide rhetoric. And the same with the NHS's suicide czar, who issued a statement last year that doctors need to stop saying this. It's not true. And it actually, because suicide is a socially contagious behavior, it implants the idea into the kid's mind and actually increases the risk that the kid will try to self-harm. So that's the second reason, that parents are almost always given incomplete and inaccurate information, and therefore their consent is not truly informed and not freely given. Third, although advocates of gender-affirming care like to claim that this should be left to parental discretion, what they really mean is, in practice, the discretion of parents who want to sign up for gender-affirming care for their kids. I cannot tell you how many parents I've spoken to, almost always dads. It's always almost the mom that wants to proceed and almost always the dad who says no, or at least is skeptical. I cannot tell you how many parents I've spoken to who have told me, my wife and I disagreed, but the gender clinic shut me out of the process. They concealed information from me. They would only communicate with my usually former wife, because they often get divorced over these types of controversies. Jamie Reed, who again was the whistleblower from the St. Louis clinic, attested in a sworn affidavit that their clinic used to actively keep the non-affirming parent in the dark. The clinicians would hide information from the parent who was skeptical, who had questions, who wanted a more comprehensive mental health assessment, who wanted psychotherapy. The gender clinics would just keep them in the dark. So that's the third reason. And then the fourth reason, which I've been trying to make the case for this, and I wish people would take this a little bit more seriously, I think the parental rights argument is a very convenient ploy by gender clinicians to deflect responsibility for what they're doing. Because what they're essentially saying is, the parents are the ones who bear responsibility for this decision. What do you want from us? Leave us alone. They consented. And especially because in this area of medicine, the model that's being used is known as the informed consent model. It was borrowed from adult transgender medicine and imported into the pediatric context. So essentially what they're claiming is, as long as the parents sign off, leave us alone. Don't come after us, right? And so this is a very convenient strategy of deflection that also probably has some legal implications, although we're yet to see that play out because the medical malpractice suits, of which there are almost 20, are still in their early phases. So that's for the medical side of things. Very quickly on education. When it comes to education, I think there's thousands of school districts across the country that have either written or unwritten secret gender transition policies, by which I mean on demand, regardless of a kid's social circumstances, family history, mental health history, anything like that, the school will agree to use their name and pronouns, let them use whatever bathroom they want, locker rooms, planned sport teams, whatever they want. And the default thinking is parents are unsafe for their kids unless the kid says my parents are safe. And only then will schools notify parents. So the default is the parents are unsafe for kids unless the kid says otherwise. Now, there's kind of two arguments made in support of these secret gender transition policies. The first and they're in contradiction with one another. The first argument is that it's no big deal. It's just a show of respect, just being inclusive. What do you want? The second argument is this is a vital mental health intervention without which the kids are going to become depressed, anxious, and want to kill themselves. Well, I'm sorry, both of those things can't be true at once. If it's true that this is a vital mental health intervention, it follows that schools are performing mental health therapy without a license, which is troubling in itself. So far, there has only been one systematic review of evidence on the mental health consequences of social transition in children and adolescents. It was done as part of the CAST review, and unsurprisingly, it came back with the finding that there's no credible evidence that that social transition is linked to any mental health benefits. We don't know. We simply don't know. There's no quality evidence to support it. What we do know, based on decades of research, and this is a complicated issue, I'm happy to tease it out if anybody wants, but what we do know is that social transition appears to be iatrogenic, meaning it locks in a state of gender distress or gender confusion that in the vast majority of kids would disappear over time, usually through the process of puberty itself, which is clarifying for many kids. Most of these kids, believe it or not, come out as gay. So schools transition kids behind their parents' back, set them up for medical treatments that have irreversible and harmful consequences where otherwise the kid, if he had not been socially transitioned, would almost certainly have desisted and come to terms with his body and his sex. And that's why I've called this the school-to-clinic pipeline. So in this particular case, sometimes the only tool that parents have to stop this process, the school-to-clinic pipeline in its tracks, is being notified. And many of these parents facing a relentless campaign by school counselors, teachers, administrators, civil rights advocacy organizations like the ACLU that bully schools into adopting these policies. The only recourse that parents have is to get their kids out of school, and that's what many do. Thank you.
Thank you. All right, so I'm going to try to, these are obviously very disparate presentations. I'm going to try to sort of draw out some threads that I think are really important. So Maxine, you talked about how parents are getting children the medical care they believe their children need. And I think that this is a thread that maybe I'd like all of you to address, because it sort of gets at a lot of the different beliefs that parents will have, but the question of to what extent we should be accommodating those beliefs is obviously very important. And we could diagnose this as a mental illness. We could say this is a religious belief. Parents could have all sorts of reasons for believing that their children deserve a particular or need a particular kind of medical care. But I guess I want to sort of try to draw each of you out on where that line should be drawn. So Mike didn't speak a lot the first time around. I want to give him a chance to sort of talk a little bit about some of the cases that he's looked at and how he thinks, how you think this line should be drawn in those cases.
Well, and the line for me is very clear. Is there a criminal offense? And I investigate them to the point where I can either prove that there is or prove that there isn't. And I think it's very important for people to realize that police investigations not only convict the guilty, they also clear the innocent in many cases. And on medical child abuse cases, I've cleared people who have been innocent.
So these are cases like the ones that Maxine was mentioning.
Correct. Munchausen by proxy. And I think it's important. The creator of that term was a pediatrician. He was not a psychologist. This was initially meant to be applied to the abuse of the child as a society, because we have decided we don't want to accept the fact that a mother could do this to a child. We have switched that around and applied it psychologically to the mother, which is kind of an excuse for the behavior. This is abuse. They present no different in an interview setting than any other child abuse perpetrator. They will confess, or confess is a bad word. They will give admissions. I've gotten admissions from 4 or 5 of them. And they will never tell you the whole truth. And that is every sexual abuse interview, that is every physical abuse interview that I've ever had. Specific cases we can talk about. George Honeycutt is his son. His wife was medicating his son with clonidine and then taking him to the doctor. It's a sedative. Taking him to the doctor to present symptoms of normal pressure hydrocephalus. And she did that and got a brain monitor placed inside his skull. Unneeded surgery. The doctor saw actual symptoms because she was drugging the child. Right? And this is the behavior that we get into when we get into the cases that I investigate, right? The more serious ones are going to come to me. Some of the ones that I couldn't investigate, we had a mother, she'll probably end up abusing her child, and we'll have to wait to let her do something before we can do anything. She's continually presenting her child as having cystic fibrosis when there have been multiple genetic sweat tests done, and the child doesn't have the disease. but she keeps going to doctors and keeps presenting that diagnosis to try to get what she wants. Maxine didn't talk anything about a police investigation in these. And we can do so much if we choose to, right? The importance of medical records in these cases and reviewing those medical records, when she talks about discrepancies, what we see when we go through these, because I've done this, you see intentional lying always to the negative of the health of the child. And you will see mom present the child, have things, say, oh, it was diagnosed at this other place where it was never diagnosed anywhere. All to attempt to get medical care for the child. I then can get personal writings from that mom. In the George Honeycutt case, she had claimed the child had cerebral palsy, 3 other medical conditions that the child never had. And may these kids have some underlying medical? Sure, but when you put the stat up there that says underlying medical, you need to look at what in particular that underlying medical is. I've had, for instance, if they have asthma that needs an inhaler as needed, and that's it, that's an underlying medical condition, right? That doesn't mean you need a feeding tube. A lot of the cases we see are gastric tubes. Hope Ybarra got a gastric tube unneededly placed into her child, a central line placed, and then she started poisoning her child with pathogens from her lab that she took home through a breathing treatment. And she's admitted, she'll talk to anyone. She'll tell you that she does these things. To deny this in total is really, really scary for children. Since 2019, I've filed 12 criminal cases on offenders in one Texas county on medical child abuse. It's there, police simply aren't investigating it. CPS in Texas has no policies on medical child abuse. They provide no mandated training to their investigators. When a report is called in, they have no way to classify it, so oftentimes they'll classify it as medical neglect. And so when your 25-year-old fresh out of college CPS investigator goes out to one of these calls, they're gonna see a mom taking their kid to the doctor all the time. What do you think they're gonna do? They don't know what this is. They're not taught, they don't know. They're gonna close that complaint. Pediatricians in my state have an hour required for human trafficking education for their CLEs. Pediatricians, they have nothing required for medical child abuse. And I would argue they're probably more likely to see a case of this than they are human trafficking, or as likely. Police have no training on this. Family court, the last article in the Juvenile and Family Court Journal on this abuse was in 1990. Attorneys and judges don't know what this is. And I've read some of Ms. Eichner's writings, and she writes that the family court would just automatically accept a medical child abuse diagnosis. That is completely untrue. I can tell you that from very personal experience. I serve on the American Professional Society on the Abuse of Children's Munchausen by Proxy Committee. The other experts on that committee who have testified in family court can tell you the same thing. And Dr. Feldman would tell you he's testified numerous times that this is what it is, and the courts have ignored him and given the kid back to mom. And these offenders, especially the more advanced ones that I'm going to see, they have a compulsion to do this abuse. They do not stop. I've had cases where the abuse was reported. One case in particular, Brittany Phillips, reported 4 times to CPS, nothing done. Had another case where it was reported on her own child, and then she did it to her granddaughter. When CPS gave her custody of her granddaughter, even though she had reason to believe for medical child abuse on her own child. So there are numerous issues, and I hope Ms. Eichner would join me in calling for education, for law enforcement, for doctors, for CPS. Would you join me in calling for them to educate them on how to actually approach these and investigate these properly?
Not only that, I would actually join you in trying to get accurate standards to distinguish between the many parents with children with legitimate medical illnesses who are just trying to do the best they can for their children and those heinous parents. Do you understand the ratio?
Ma'am, I would never see those cases because my doctors would never report them. My child abuse pediatricians would never report that type of case. The cases I get reported are criminal law violations, where they've actually done something to their child that was unneeded.
And have you read the Houston Chronicle series by Mike Hixenbaugh that shows
I'm very
repeated
familiar.
medical diagnoses?
Very familiar with Mike
misdiagnoses?
Hixenbaugh, and Mike Hixenbaugh is not honest in his articles.
And
So I just want to interrupt because we are running out of time before we take questions from the audience. So think of your questions.
I would actually happily answer your general question, Naomi.
Okay, but we haven't heard from Emma in a long time, and I feel like I just want to draw out sort of one thing that I think was important in some of the themes of what Emma has reported on and what Lior was talking about, which is this question of of parents choosing among available, approved medical procedures and techniques. And I know, Emma, you wrote a little bit about this, the Take Care of Maya case, which became famous because of a Netflix movie. And in that case, the parents actually left the country to have their daughter, if I understand correctly, have procedures that are not necessarily approved in the US for her diagnosis. And so I was wondering if you could answer this question of, how we are drawing the line about parents getting children the care that they think they need. How far outside of the kind of these approved choices should we be going, and how should we think about parents who, of course may have the best of intention, but, just to bring up something that came up on the previous panel, like, maybe they're engaged in faith healing, maybe they're going to another country because that's where they could get, female circumcision for their, there are all sorts of, once you expand the options to anything a parent believes that they need for their child, we could be entering some dangerous territory. So I was wondering how you draw that line.
That's quite a difficult line to draw. Right now, I'm thinking about this most as it relates to these sort of gender-affirming care, child transition cases. And for example, in Texas in 2022, there was an order put out by, I believe, the Attorney General, basically saying we are going to investigate parents who are getting their child medical transition treatments as if they are committing child abuse. We have decided that's child abuse. The first problem with that is these treatments were fully legal in Texas at the time. They've now been banned. So you were having, CPS workers knocking on the door, investigating parents who were getting medical treatments that were presented them by doctors as being effective and safe and what they should be doing for their kids, who were basically seeking out these treatments in good faith. And while I think in terms of what I think about the evidence base for these treatments, I'm inclined to agree more with Leor. I still think that Child Protective Services, government coming and investigating or possibly removing children, that is not the appropriate use of that agency to sort of solve these medical controversies over what the correct treatment course for an illness is, when, especially in America, there's such, if you're a parent who knows nothing about this and you have a child who's suffering, I think it would be really difficult to know what to do. Obviously, there is a line. I think a good example is, if a child has cancer and parents are saying, no, we're not going to give our kid chemo, we're going to do faith healing. I think that might be a reasonable point to say, well, this child's going to die if they don't have medical intervention. But actually drawing that line is something that, I'm not giving a very satisfying answer because I'm basically saying, I don't know, this is really difficult. But I think the seat of where this is being debated most in our culture right now, which is gender issues, I think is a good candidate for a case in which parents who are seeking out medical care or not seeking out medical intervention in good faith should not be treated as medical child abusers.
Okay. And then Leor, and then we're going to, okay, you each get 2 sentences. And then we're going to turn it over to questions. So,
I just want to say, I agree with Emma completely. I mean, I think the Texas approach in 2022 was just, it was imprudent, it was unethical to go after parents. And I think it also, it kind of underscores this idea that I'm trying to reject, that the responsibility should be laid at the feet of parents. The problem is the clinicians who are ideologically driven and telling parents that this is what they need to do in the first place. And going after parents just kind of feeds into that narrative that this should be about what parents decide to do. So I agree with that, yeah.
All right. Go
We
quick.
actually have long-standing constitutional dictates by courts that distinguishes when the state can intervene when parents are making choices that may seem unwise for their kids. The general rule is parents have constitutional rights to direct their kids' medical care. That's because we think parents generally know their kids best and are most motivated to find out what's in their children's best interests. Now, there are limits on that because sometimes parents make really poor decisions. And the way courts have crafted those guidelines say that the state and doctors can intervene when the parents are choosing a medical course that no legitimate doctors in the community support and that could result in extreme harm to children. Those guidelines have been around for 80 or so years. They have worked very well. My own view is there is no reason to intervene with those guidelines.
All right, questions from the audience. We have microphones right here.
Thank you all for coming. My question is for you, Mr. Sapir. Is that correct? Sorry.
Sure.
All right. Well, my question is about some of the laws that enable states to take custody of people who identify as transgender from other states. There's a case of the state of Minnesota where they say the cliche is that it's a trans refugee, but their argument is that, well, if you don't treat this child with gender affirming care, then that's child abuse, akin to letting a kid with a broken leg just sit there and suffer through the pain. But in any event, they've taken custody from lots of parents concerning this, and the courts have done it through that alone. So can you just elaborate on that, and if that's also occurred in other states?
Yeah, I mean, it's a great question. So this is part of this kind of spiral that we're seeing playing out in the political realm, where Republicans propose certain measures and Democrats outdo them on their side, and so on and so forth. And these so-called sanctuary state laws were a response to the red state bans. And essentially what these laws do is they instruct their kind of in-state authorities to not respect things like court orders from other states, right? So if, let's say you have a court order from Texas, siding with a non-affirming parent, and the mom takes the kid to California, being a sanctuary state, under this sanctuary state law, the health authorities in California can disregard that order. You can see why this is almost certainly going to go before the Supreme Court at some point and implicate the full faith and credit clause. There's a serious problem here. But look, all of these controversies, political, regulatory controversies, are of course downstream from the underlying medical and ethical issues. And that's why, I'm in my work at least, I try to keep the focus on the medical issues themselves. Because my view is we cannot resolve the medical issues by debating the political and legal fallout to those issues. We have to keep the focus on the medical issues themselves. But yes, it is a serious problem. I don't know how common it is. I've actually asked folks who are kind of in red state governments, how common is this? Nobody knows. Okay. No idea.
We have a question online, and it's actually something I think is really an interesting tension between what Maxine is saying, what Mike is saying, which is, are these cases overreported or underreported? And I think from Mike's experience, it sounds like he thinks that they're underreported.
Absolutely.
If there are this many cases in this one county that are being investigated, I think maybe you would say, because you've been trained in this and most of the people in other counties are not. And Maxine, you're presenting evidence that suggests that there is overreporting going on. But the question is, it gets at this, the 76% statistic. I think the question here is about the denominator. So this person, this researcher was asked to review 115 cases. Were the 115 cases that were reported, offered to her because there were suspicions of child abuse? And so what does that just, I think the question is, if there are suspicions of child abuse, maybe 76% is the accurate number. I mean, it is bigger than the number from before, but maybe we're just dealing with a lot of underreporting and trying to match these numbers that's the problem.
So it's an excellent question. It would be really good if somebody had actually taken time to investigate whether Mike is right. And all the cases in which child abuse pediatricians are reporting medical child abuse indeed have that heinous behavior. But child abuse pediatricians have never investigated that. There's been no empirical investigation. The reason that my, stronger than a hunch, my contention is that these cases are grossly overreported is, first of all, you've seen that 76% figure that I gave to you, and the expansion that I showed you between the Munchausen syndrome by proxy diagnosis versus the medical child abuse diagnosis, and the fact that most of the parents who are targeted today, 3/4 of them have children with legitimate medical illnesses. Over and above that, by child abuse pediatricians' own studies, what they have found is that the rate of Munchausen syndrome by proxy is 2 in 100,000 children, or 1 in 50,000 children. The rate of children with complicated medical issues or rare illnesses, as I've told you, is 1 in 20. That means that there is one child who has been abused by over-medicalization for every 5,000 children with a rare or complicated medical illness. The diagnostic criteria that people look at for suspected medical child abuse picks up many of these kids. So the idea that 3/4 or 2/3 of the children who somebody reports as suspected for medical child abuse should be diagnosed with medical child abuse strikes me as way
What's the number
high.
of people who are being reported for medical child abuse?
The number of, we don't actually, so we don't have figures on the number of people every year. States don't break it out that way, who are being charged with medical child abuse. Who are reported. The best statistics we have are the statistics I gave you from Carol Jenny saying, of all the kids who were suspected, who were referred to her, 2/3 of them she has diagnosed with medical child abuse.
Right, I just think we may be dealing with a very tiny number of people who are actually reported for this.
Well, those were, she was,
that's why my question was about the denominator, but I don't want to get hung up on this too much.
I wrote a New York Times column in 2015 that computed that. Back then, there were not a large amount of people, but recognize if 2/3 of those not large amount of people are then being found to have committed medical child abuse, that's way too high.
Well, I don't know if the number is 40, maybe it's not too high. I mean, I think we're having a statistical problem here, but I just want to let Mike respond, and then I want to have time for one more question.
We actually do have some pretty good data on it. There's a 2022 study out of Seattle Children's. They looked at 145 cases, suspected cases over a 5-year period. They had a board set up. Everyone had to agree that it was medical child abuse, and they only did this through medical record review. They didn't have any police involvement. Why? Because police there don't investigate these cases. And out of those 145, they diagnosed 65 cases of medical child abuse positively, 37 that they didn't know one way or the other.
Mike, it was a medical records review.
Exactly. This is an evidence-based diagnosis. You don't go look at a child and see if they're being medically child abused. That isn't the way this works. You look at the behavior of the offender. And again,
Tell me why you think tell me what evidence you have to support your contention that relying on medical records gives an accurate so-called diagnosis.
I'm telling you that's the best research we have. I don't rely on medical records. I go out and get additional evidence. That's what police should be doing, and they're not doing on these cases because they don't understand how to investigate this or that this is a crime. And this is, when it rises to the level of a criminal violation, it's absolutely criminal behavior. And they know what they're doing. They know what they're doing is wrong when they're doing it, which is the legal definition of sanity. And any expert on this abuse will tell you that.
All right, I think we have one more question. Back? No?
Just a comment. We're suggesting that underreporting and overreporting are opposites rather than both occurring at the same time, which is a much more likely scenario and talks to the quality of our decision-making, the quality of our data, and the quality of our standards. So we should not ignore both sides of the equation.
I consulted with a detective in Texas that's in Montgomery County on his first case, gave him the playbook how to do it. Once he recognized what it was, he now has 6 additional cases on his caseload. No one was investigating him down there before. Will they make criminal cases? We'll see. And again, I want to go back to this. It depends on the individual evidence in that individual case. Always.
Oh, one more. Here we go.
First of all, I want to say Mike is part of APSAC, which is really a highly respected organization that does evidence-based research that I deeply respect. But is it Sapir? No, who cares, right?
Yeah.
Yeah, I know. I get called the wrong name all the time.
We care a lot.
I'm with you. I'm with you. So you just said something in passing, and I just want to make sure I understand what you were saying. You were saying that the systemic evidence, that the social transition, respecting social transition, locks in gender distress that would resolve itself by itself, and then most of these kids turn out to be gay. Is that true statistically? Most of these kids turn out to be gay?
Oof, complicated. We'd have to really go down the rabbit hole of research to answer this question properly. The historic research on this, dating back 40 years, that produces the high desistance figure, 85% or more, does show that the majority of these kids are gay. So if you look, for example, at the Dutch clinic where they first started experimenting with puberty blockers, the puberty blocker cohort, I should say the final cohort after they went through the whole course of transition, out of 55 kids, no, actually it was the first, even before the surgery, out of 70 kids in the cohort, all but one was same-sex attracted. They're all gay in that study.
Right. So
yeah.
So doesn't that indicate that the distress may also come from being gay in schools and culture that's not accepting?
That's the Occam's razor explanation. That's the most likely explanation. And in fact, I mean, even the Dutch clinicians, so Thomas Steensma is one of the kind of founders of this field, published a paper in 2013. It's called Factors Associated with the Persistence of Gender Identity Disorder, something like that, or gender dysphoria. And he said, yes, cross-sex identification and related distress is far more predictive of future homosexuality and the resolution of gender identity issues than of adult transsexualism. But as befitting the Dutch, they see the problem and they just say, don't worry about it. Puberty blockers are totally reversible. Kids can come off them whenever they want. We know that's not true now based on research.
So, Europe has done what it's done, and
Right.
it's evidence-based, so I'm very interested. And I'm not going to make, but if you're going to say that schools should not have gender-affirming attitudes, right? What then do you fill that up with? You've got children in very difficult situations, and it's not just caused by the fact they think they should be another gender or the society. It's also caused because at base probably they're gay. So what do schools do to help those children?
Again, it's a great question. Complicated, of course. I mean, I think that the thing that we should all be able to agree on is that parents should be in the know and directing these decisions and not kept in the dark. But if you're asking what should schools do, look, I think it's part of normal and healthy child rearing to communicate to children scientifically accurate information about sex and gender. That's a minimum. I don't want schools teaching kids pseudoscience. I don't want them teaching any kind of pseudoscience. Sex is not assigned at birth. And any school that teaches that, I mean, I looked at the curriculum of the school district where I live, and they start this, it's indoctrination. I will say that.
Okay, we're going to disagree on assignment at birth, okay?
Okay.
So that's fine.
Yeah.
But my point is that if you know that these distressed, and these are very distressed children, if you know these distressed children are in these schools and are going to be coming out gay, don't you think the schools need to have much better support for gay children?
Depends what you mean by support, doesn't it?
I mean, they can't be bullied, they
Of
can't
course.
be,
Yeah.
well, but that's not of course.
No,
That's not
of course, I agree with you that they
it's
shouldn't be
also,
bullied.
and I'll just end on, it's not of course that they're safe at home, right? The people,
That's true, yeah.
the gays who will line up to describe the horrors of what was done to them, usually in the name of religion because they were gay, is enormous. So you can imagine why teachers want to protect them. Now, what teachers probably should be doing is reporting those parents to the authorities.
Yeah, and then what happens with CPS when they do, right? That's part of the problem. But I agree with you.
Let's not go to the adults. Let's talk about the children, right?
Well,
the children.
okay, but CPS is the one that would investigations.
Well, these children are suffering at school and home. So I think the easy idea that you automatically tell parents that you know are harming a child, in my book, is not the answer.
All right, we're going to let Lior respond.
We can agree to disagree on
Don't
that.
agree on it.
Okay. You guys have made it to lunch. Congratulations. All right, we are going to take a 15-minute break before our final panel, but please join me in thanking our panelists today.
I'm Emily Putnam-Hornstein. I will be moderating the third and final panel for the day. I want to thank Naomi and AEI and others for hosting. This panel is called Protecting or Overreaching Parents' Rights and Child Welfare Interventions. It needs very little introduction because, of course, the question as to whether the system is effectively protecting or overreaching is hardly novel or new. Nor is the fact that we often have some very interesting and strange political bedfellows in child welfare. In fact, to prepare for this panel, I decided to do a quick Google to make sure that I was going to be using the correct terms. And I first stumbled on parental rights movement, which Wikipedia described as a socially conservative political movement aimed at restricting schools' ability to teach or practice certain viewpoints on gender, sexuality, and race without parental consent. But at the very top of the Wikipedia page, they had a disclaimer that this was not to be confused with the parents' rights movement, which was described as a civil rights movement primarily interested in human rights affecting related to family law, including child custody. I'm not sure if there's a real distinction. Maybe there is, but we will be talking about both. I'm really thrilled to be joined by a terrific panel. Each panelist will spend a few minutes just talking about their work and reflecting on this particular space. We'll then have a moderated discussion with time for questions at the end. For those who are tuning in online, my understanding is that there are instructions as to how you can enter those, and I've got an iPad here. So first, Will Estrada. Will is a senior counsel for the Homeschool Legal Defense Association. He also served as the first president of parentalrights.org and the Parental Rights Foundation. Chris Gottlieb is the current director of NYU Law's Family Defense Clinic and an assistant professor of clinical law. Tom Rawlings has a long career in juvenile justice, child protection, and capacity building. He served as the state of Georgia. He served the state of Georgia as an attorney, juvenile court judge, child's rights ombudsman, and director. And Ron Richter is CEO and executive director of JCCA and a former New York City family court judge and commissioner of New York City's Administration for Children's Services. So will you kick us off?
Thank you so much, Emily. It's a privilege to be here. I very much enjoyed the other panels and the discussion. In 2018, the organization where I work at, Homeschool Legal Defense Association, filed a federal civil rights lawsuit on behalf of Holly Curry and her family. Holly is a mom of 6 kids. A little bit prior to this, so in 2017, she was taking all 6 kids to karate class, homeschool mom, and she stopped at the local convenience store to pick up muffins for her kids. She came back about 9 minutes later, and 2 sheriff's deputies were out there. They told her she could not leave her children alone. Even though she had not broken any laws in Kentucky, they had to refer her to Child Protective Services. The very next day, Holly had someone knocking on the door. She went there. The person said, "I'm a social worker. I need to come in and interview your children." Holly knew her rights, so she said, "Well, you need a court order, but I also want to see some identification." Social worker refused to give identification, refused to produce any warrant or court order, and said, "Let me in, let me talk to your kids, or I'll remove them." Holly said no. Social worker left. A few minutes later, a few hours later, social worker came back with a sheriff's deputy, said, "We will remove your children, we'll go get a court order if you don't let us in." So again, importantly, even though she had a sheriff's deputy with her, she did not have a court order. Holly, in fear of her children being removed, let the social worker and the sheriff's deputy in. The children were interviewed. The children were strip searched, all 6, including the female children, minor children, in front of a male sheriff's deputy. Soon after that, the caseworker closed the investigation as unfounded. We filed this civil rights lawsuit, and we won. We got a $500,000 settlement on behalf of Holly Curry and her family. But that is why this issue is so important and so passionate to me. In just the past couple months, I've had 2 families in Massachusetts who withdrew their children in order to homeschool them. Both had founded cases of child neglect against them simply because they pulled their children out of public school before they had received approval from the school district in order to homeschool them. Massachusetts and Rhode Island are the only 2 states in the nation where you need approval before you can homeschool. The rest, you just notify the authorities and then you're good to go. This is what we see day in, day out at Homeschool Legal Defense Association, and it's why I'm so passionate about reforming this system, because it is stacked against parents and parents' rights. One important thing I want to just say with my remarks is there's a distinction between abuse and then neglect and maltreatment. You abuse a child. We had in our first panel, there was a discussion about sexual abuse. I personally think the person should be thrown away, the key should be thrown away. I mean, there is no rehabilitation for someone who does sexual abuse of a child, and the same sort of thing for physical abuse as well. But when it comes to maltreatment and neglect, it's a much more nebulous term, as you saw in this discussion of what is child neglect, what is medical neglect. So that's a very important distinction to draw. Is corporal discipline abuse or neglect? Is refusing to vaccinate on the CDC schedule, is that abuse or neglect? It should not be. So we need to be very clear of what is abuse and what should be punished and criminalized and people thrown in prison, and what is parents making decisions of what's best for their children. And I might make different decisions than Emily or Chris may make. We both love our children very much. 2 things I want to also just bring to your attention in my opening remarks. It is very important to talk about children's rights. And our system in our United States government, and Parham versus JR is probably the best case in 1979 of our system of government trusts the parents to make what's the best decisions for their children. Because a 5-year-old or a 7-year-old and 11-year-old needs help and guidance. And so this whole thing of, oh, children have rights, who's going to be helping children and protect their children? Is it going to be the parents, or is it going to be a bureaucrat or a government official? And I will always side with the parents unless there's been a finding of abuse or harm to the child. I encourage you to read the writings of Shanta Trivedi. She's an attorney. She's at the University of Baltimore School of Law. She has written very extensively about the harm to children from Child Protective Service investigations. Another one that's very good is Doreen Lambolet-Coleman, she's from Duke School of Law. In 2006, she wrote a law review titled Storming the Castle to Save the Children, the Ironic Costs of a Child Welfare Exception to the Fourth Amendment. These CPS investigations, from anonymous allegations, from mandated reporters who know that there's no abuse or neglect, but they're worried about losing their license, they have real physical harms to children and to families, as well as to our constitutional protection. So I welcome this robust discussion, but I would encourage all of us on this panel and all of you as practitioners and experts, there are a couple things we should agree on because our system truly needs reform. The first is we have got to eliminate anonymous reporting of abuse and neglect. I see this constantly of an ex-spouse or an ex-boyfriend or girlfriend or just a nosy neighbor reporting families for abuse and neglect, and they're too gutless to put their name to it because they know they could be prosecuted. We have got to eliminate anonymous reporting of abuse and neglect. We have to eliminate mandated reporters. Now, not eliminate mandated reporters, but eliminate the requirement that people be a mandatory reporter. I have seen so often families fearful to get the help and social welfare or counseling for their children because they're worried that there will be reporting and their families could be torn apart. Let's trust these experts to know when they need to file a report. Let's not mandate them under criminal penalties or loss of licensure to report families for abuse and neglect. We have to put in place more due process protections. Texas has led the way. New York also has put in good protections of families being told their rights when a CPS investigator comes to their home. And fourth, and we had a robust discussion in the past panel, we have to eliminate these child abuse pediatrician positions. The medical kidnapping, the medical neglect charges. As we saw, this whole panel of experts couldn't even agree on what was medical neglect. And when you're a hammer, everything is a nail. And that's what happens with child abuse pediatricians. The real cost of this, I've had hardened veterans from Iraq and Afghanistan that I've helped crying, breaking down in tears because their 3-year-old had gone down the sidewalk to go visit his friends because they were afraid of their children being removed. I've seen attacks against homeschooling. There's an organization called the Coalition for Responsible Home Education that just adopted a model bill that calls 23 pages. It would turn back the clock on homeschool freedom. And what it would do is it would say if you even have been investigated by Child Protective Services 3 years prior, you cannot homeschool. Not even a finding, just an investigation. These are real world impacts from a system that is stacked against parents. Do I have a second to just read a real quick quote? And this is from the Curry decision that I referenced at the very beginning of the family that we represent in Kentucky. Here's what the federal court said. Act 1, an attentive and loving mother gets muffins for her children. Act 2, there's a knock on her door and a threat by the government to take away her children. Act 3, her children are strip searched without cause. America's founding generation may never have imagined a cabinet for health and family services, but they knew their fair share of unwelcome constables, and they added a Fourth Amendment to our Constitution to protect against this 3-act tragedy.
Thank you.
Hi, everyone. Pleasure to be here. Want to thank the American Enterprise Institute for putting together this really important conversation. As Emily said, I teach at a law school. I research, study child welfare. But my real expertise, to the extent I have it, I believe, comes not so much from the study, but from working side by side with children and parents who've been enmeshed in the child welfare system. I began my career representing kids because I wanted to help kids, and pretty soon what I saw was that the way to help kids, by and large, is to protect the rights of their parents. And my clinic now at NYU represents parents. And in the representation of hundreds and hundreds of children and parents through most of my career, I spent a lot of time wishing that the media and politicians would pay more attention to parental rights. And I guess that's a lesson in be careful what you wish for, since now the topic is at the forefront. And in many ways, it is being, parental rights are not always bringing out the best of our society in the culture wars. But I deeply believe that in the realm of child welfare, we actually have opportunities to see folks from across the spectrum coming together. And I think it's worth starting out this conversation by just reminding us of some of the things we all, wherever we are politically, agree on. It should go without saying we are all deeply anti-child abuse. We all believe that the vast, vast majority of children are best off being brought up by their parents without government intervention. We all believe that preventing child maltreatment is better than dealing with it after the fact. And I think that we all agree, even those of us who are more big government in some ways, I think we all agree that one thing government is not good at is raising children. These are the overarching points of agreement that I think can inform our child welfare policy. Now, those big picture agreements have not always translated into agreement on particular policies, but I think there's room, particularly in this moment, I'm actually very optimistic to see folks left and right coming together. And I want to name at least two of those areas as we start out this conversation. One overlaps very much with what Will just said, although we didn't coordinate it, but I think it is an issue where there's just an emerging sense that our reporting system has gotten out of control. Nobody who set up child abuse registries and created mandated reporting ever imagined or intended that it would lead to the massive system of investigation that we have today. Just to put a few numbers on it, I mean, in 1980, 1 million reports of child maltreatment were reported and investigated every year. One might think that's a high number. By 40 years later, 4.4 million reports of child abuse and maltreatment. And I don't know anyone who believes that there's anything like 4.4 million families that need or would benefit from government intervention. And you know, as Emma said on one of the panels earlier, investigations are not harmless. They're not neutral. These are traumatic. They're traumatic for the parents, and more importantly, they're traumatic for the children involved. Strip searching, one obvious example of the harm, but just having the government come in, often in the middle of the night, wake you up, and give you the message that your parents are not in charge, that you can no longer be confident where you're going to be sleeping the next night. You're not safe in your own home. I mean, that's a harm that is often underestimated. So I do think reducing the unprecedented size of this reporting system, I mean, mandated reporters around the country are saying they don't want to be forced to report things where they don't actually believe there's a problem, but they're feeling this pressure. They want to be supporters, not reporters, is the refrain I'm hearing over and over again. And certainly it includes, the next step should include, as Will suggested, pulling back on the idea that anonymous reporting is not only allowed but encouraged. Texas has already made a change. It would still be confidential reporting. That is, the names of a reporter would not be given to the subjects. But anonymous reporting just invites abuse. We know this. Domestic violence survivors unfortunately know it more than anyone, that the system is often misused by people making purposely, maliciously false reports. A lot more to be said about that, but I just want to put on the table the other area where I see folks coming together from really all over the country and all over the spectrum. And that is on another area where the United States has gone in a simply unprecedented direction, which is the idea that we now celebrate destroying family ties. Termination of parental rights is a concept that was not known in history until about the middle of the 20th century, when child welfare officials developed it, brought it into the law. But it was created, if you look at the history, it was created to allow children who had been abandoned by their parents to be adopted by the new caretakers with whom their own parents had placed them. That was the structure in which termination of parental rights was introduced, and largely the situation in which it was used well into the 20th century, toward the end of the 20th century, when Congress decided that the way to deal with the overly large foster care population that we had was to start financially incentivizing the destruction of family ties. And it is since 1997 and the adoption of and Safe Families Act, our federal government now financially rewards states when they terminate parental rights instead of reunifying those families. And we're not talking about, by and large, cases where the children were abandoned, and we're not talking, by and large, about cases where the children were abused. We're talking about cases where very often the parents are struggling with social maladies of our age, drug use issues, mental health issues, domestic violence issues that we see in all walks of life. But if you are in a low-income situation, those issues now, under federal law, very often lead to termination of parental rights. Many of those kids whose rights to their family have been terminated will never be adopted. They're legal orphans. Others will be adopted, but may unnecessarily be cut off from the families that they're still emotionally connected to. Many will return to their families when they're old enough to make that choice themselves, and others tragically will not be able to reconnect. And it is hard not to look at the history of child welfare in the United States and see that again and again, when we've destroyed families, those have turned out to be the most shameful moments of American history that we now look back on with regret. And I hope we're in a moment now where we can pull back on the purposeful destruction of families that we're doing by terminating rights and move toward other solutions for our children.
Well, good afternoon. It's great to be with y'all. Thank AEI for inviting me as the least distinguished member of this panel. So over the last 25 years, I've handled cases, child abuse and neglect cases as a judge. I spent several years as the child advocate for Georgia, where I got all the complaints, everybody who had a complaint about the system. Ran the system. I'm a child welfare lawyer. I've litigated these cases. And I found it really interesting this morning that we spend a lot of time talking about what are parental rights, what are children's rights. I do have a few thoughts on that. Number one, I think it's certainly clear that, and in fact, all of our constitutional Supreme Court comments on this have been consistent. The custody, care, and raising of children resides first in the parent. But we also have to remember that whose primary function and freedom include preparations for obligations the state can neither supply nor hinder. And as Marcy, I think, said earlier this morning, parents can become martyrs themselves, but they're not free to martyr their children. So there is, I think, an appropriate balance that is reflected in most of our laws, that yes, parents, the role of the parent is to raise the child. And the obligation, because every right has an obligation that goes with it, the obligation of the state is to stay out of that relationship to the extent that the parent is acting in a reasonable, minimally competent capacity. I think, though, that for those who would say that there aren't really any children's rights, or those who would kind of downgrade those, I think that, and one of our speakers this morning made this very clear, I think it was James, the real issue that I would say that children's rights are subsumed, so to speak, within the parental family unit. But there do come times when the parent's the parent is not doing what they're supposed to be doing. There comes a conflict between what the parent wants. Sometimes that is the parent wants to abuse the child. Sometimes that is the parent wants to do a lot of drugs and ignore the child. Sometimes it's the parent is more concerned about the violent relationship he or she is in than they are about the child's well-being. And it is in those situations where we have to start thinking about what is the child's right. So the problem here is that, as you said a minute ago, there are 4.4 million reports made to some child protective agency in the United States each year. Of those, half of them are screened out. Of those, another half are nothing really happens. There's only about 300,000 children a year of all those reports who receive services, and only about 150,000 who actually are placed in foster care. But think about the fact that we have this incredibly important balancing act of the parent's duty to the child and then the state's duty to intervene in the parental unit only when necessary. And who is handling all of those 4.4 million complaints? A bunch of 25-year-olds, as someone said earlier, right out of college, who aren't lawyers, who don't know how this works. And our laws, quite frankly, are oftentimes confusing. On the one hand, we have demanded that, for example, if a hospital has a child who's born and the child tests positive for a regulated substance of some sort, that they must report that to authorities. The idea, of course, is not that that child should be removed necessarily, but the truth is that the agencies that are responsible for responding to those cases, they don't really know what to do. And so, for example, in New Jersey recently, even though the hospital was doing its duty of reporting prenatal substance exposure, the Attorney General of New Jersey, who represents the Child Protection Agency to whom these reports were being made, sued the hospitals and told them to stop doing that. And so imagine how confusing this is for a bureaucracy, for a bunch of 25-year-olds simply trying to do their job. We're giving these young people this massive burden of trying to balance what I think we all agree is the right to family integrity. Children do best when they are raised by their parents and their families. Versus, we have an obligation to keep a child safe, and usually that's a standard of safe from imminent harm. But then again, we also see situations where there's no imminent harm, there's no imminent harm, there's no imminent harm, there's no imminent harm. For the fifth report, the child dies. And so it is a really hard thing to do. But I have a couple of thoughts on what we should do about it, I guess you might say. So, number one, we have got to, I think, clarify as a society that the work of child welfare is not something to be abolished, and it is not something where we need to focus only on the parent nor only on the child. It is a balancing act, it is hard work, and we need to put people doing it who have judgment and skill, and we need to, quite frankly, help them do a better job. Number two, I just remember this from, we've seen over the last, certainly over my career, just a loss of faith in institutions. Whether those institutions are faith institutions, whether they're the justice system, whether they're the child protection system, whether it's police, people are losing faith in our institutions. And why? Because when you are not treating people decently, sometimes that happens. And some of the things that you were talking about a moment ago, Will, removing a child because the parent left the child in the car for a few minutes. We had a case in Georgia the other day where a 10-year-old was walking down the road in a rural area, just like I used to do every day going to school in Sandersville, Georgia. And the sheriff arrested the woman for letting her child walk to school, and then probably because it seemed like somebody needed to do something, the Department of Family and Children's Services came along and wanted to make her do lots of other things. And so we have got to find a better balance. I think the way you do that is that we need to focus not on abolishing the system or on, focusing on child rights or parents' rights or anything else, but to focus on due process and transparency. So, for example, I think Emma was talking earlier about the child abuse pediatricians issue. I've done a lot of work with our local TV station in Atlanta on this issue, and what I always say is I love child abuse pediatricians, but they are not the end-all, be-all. And when the court and the Child Protection Agency simply defer to them without giving the parent an opportunity to say, look, I really didn't do anything. I need an expert to help me, but I can't afford one, and no one will testify against a fellow doctor. That would be an area where we could truly improve due process for these families so they would have more confidence in the system. Again, the issue of, we've had in Atlanta recently, the issue of whether we often use drug screens, of course, as a way to make sure that parents who are involved with the system are staying clean. We've had situations where the companies that do this testing are just, it ain't working very well. And as a result, parents feel that they are trapped. And so if you want someone to respect the system, you have to make sure the system is working in a way that respects parental rights, but also keeps the child safe. Finally, in the area, we've talked a lot, I think, Mo, today about sort of the issue of removal of children. I think there's one other issue that I think we might disagree on a little bit, which is, like, for example, ASFA. Adoption and Safe Families Act was implemented in 1998, I think, in an effort to deal with a significant issue, which is that children were being removed by the system. They were lingering in the system. They were acting out in ways that children who are traumatized by being ripped out of their homes and put in some foster home that they don't know, this is what they do, they react. So they get bounced around from placement to placement, and their mental health deteriorates. And so the question, of course, is, at what point does that child have the right to a safe, stable, permanent home that is, frankly, not the parental home. And so I think that when we talk about this balance, once we lift the veil of parental rights and the state has the capacity to intervene in the family's life, the state owes obligations. Again, that's what rights are. There's an obligation of the state to help that parent reasonably and to help that child reasonably. And one of the things that I think children have the greatest right to is family. That may be their own family, it may be a relative, or it may be an adoptive family. But if we are too focused on one end of the spectrum or the other, safety versus parental rights, for example, reunification versus adoption, then what we do is we end up not respecting and fulfilling the rights of either parent or child. One of our folks earlier today was saying that they're sort of like the UN and the United Nations relationship to sovereign states is kind of like the parental rights, child rights issue. And I think it's kind of an interesting observation, because anybody who knows how the UN works knows that it's a freaking mess. And it's a messy, large bureaucracy. And in fact, we have in this country, because we don't have a better system, we have entrusted a bureaucracy to try to implement laws that are supposed to be based upon our recognition of the right of family and our recognition of the duty to protect children. And unfortunately, we don't do a good job of that sometimes. Thanks.
Good afternoon. I'm Ron Richter, and I currently run a large child and family services business in the New York metropolitan area. It's called JCCA. We are 203 years old this year, and we've been doing sort of the same thing since the beginning, although I hope we have innovated over time. I am really thankful of Naomi and AEI for fostering this really important conversation. As someone who has been doing work related to these struggles for, I'm shocked to say, 35 years, I'm thrilled that these questions are coming to the fore in a much more meaningful way. So I want to say that I agree with the general propositions. Absolutely, children belong with their parents in their families, and there ought to be some pretty serious showings before you're able to disturb that. The fact that 1 in 2 Black children at home are investigated before they're 18, and 1 in 3 white children are investigated, or all children, I shouldn't say white, 1 of 3 American children are investigated before their 18th birthday ought to alarm all of us. Mostly because of the trauma that this causes families and the balance of power between a parent and their child that is really confronted in a harmful way to both. So I think one thing we really need to be asking ourselves is, if we're conducting that many investigations, and nationally, maybe 25% of those investigations result in something for us to follow up on, then we are creating trauma, which has long-standing implications for the well-being of our society. And we are also spending an extraordinary amount of money investigating families that don't have much need for any investigation. So I think at the outset, we should be saying that government isn't great at many things. Government has, in my view, an obligation to ensure that children are free from suffering and harm. And I just want to illuminate, when I say harm, I agree, sexual and physical abuse, horrifying. As a family court judge, though, that was not what I saw mostly. And there's been an enormous amount of conversation about neglect equals poverty. It's as simple as that. You should just buy into that. At the same time, there are many poor people raising their children without any allegations of neglect ever. And there's no question that race and economics have an enormous amount to do with how you end up in the crosshairs of the state central registry. So it's complicated. But as a family court judge, what I saw were generally mothers who had 2 or 3 children under 5 years old, who were struggling with managing that extraordinary responsibility, because I think most parents, if not all, really want to do right by their kids. And so mothers have relationships with their family and with the fathers of their children. And those sometimes, when they end up in family court, are fraught with family violence. And often those parents who are struggling with this scenario end up developing emotional and mental challenges. I won't call them illnesses, but challenges that directly impact their ability to function as parents. And often, in that same scenario, that parent self-medicates because who wouldn't? And so you have 2 or 3 children under 5 years old in a home with a parent who may or may not enforce orders of protection against someone who is often found to have been violent toward them and hopefully not the children, and a mother who's really struggling with trying to figure out how to deal with her emotional turmoil, albeit very understandable emotional turmoil. What does the government do? What obligation do we have? We are not, as a society in 2025, offering solutions for economic deprivation. We are not offering phenomenal, attentive public education. We are not offering health care that is available, and behavioral health care even more, that is available. Yet, as a government, we are told through reporting that there are these 2 or 3 kids under 5 living with their mother, probably in housing that would shock us. And as a family court judge, what are you supposed to do? Say, you know what, madam, the world has really treated you terribly. Your children can remain with you. I'm dismissing all of the allegations because that's the right thing to do. You shouldn't be stigmatized with neglect findings. That isn't what we've decided to do as a society. We've decided that in some cases, it is critical for there to be government involvement. In New York City, in 1990, there were close to 50,000 children in foster care, with 30 to 35% of them in institutions or residential settings. In 2025, there are fewer than 7,000 children in foster care in New York City, and less than 9% are in residential care. I say this because there has been tremendous effort, extraordinary effort on the part of politicians, on the part of elected officials, on the part of appointed officials, on the part of families advocating for what they need to change this system. And it has made amazing, amazing progress. So I enter into this conversation saying, I am going to continue to worry about the 2 or 3 kids under 5 years old who are living in a dangerous situation, and I'm going to continue to struggle with what to do with that family. And any creative solutions, I've thought personally, why aren't we opening something similar to kibbutz, like they have in Israel, where families that are struggling can live together and support each other? I dare say the money for that has never been available in the United States of America. So solutions have to be considered in the context of reality. And reality is that there are more than just 1 or 2 of those 3 kids under 5 living in the United States right this minute.
All right. I did not know, Ron, that you'd be coming in with the bold vision at the end there, but well done. Okay.
Do you not think I'm a visionary?
I was not suggesting that. All right, Will, I'm gonna start with you because I fear that the public's understanding of how our child protection system works is framed by the kind of the media coverage of these, I think, unusual free-range parenting cases, as well as kind of the tragic child fatalities, both of which are somewhat atypical. But since you brought up the stories, I think for every one of those, I could probably give you an example of a child who was pulled out of a public school setting because they were being abused, and the parent was using homeschooling as a shield. Now, I shared with you, I've homeschooled my children, so I am not anti-homeschooling, but I'm just curious, are there some reasonable kind of regulations that you would support that could help to strike a balance so that parents are able to educate their children, but in the very small number of cases where it's used as a shield, the state knows that and is stepping in?
Emily, that's a great question. I think that's probably something a lot of people ask. So first, on your first point of the free-range parenting, there's some, and Tom mentioned that the case of Brittany Patterson in Georgia, who let her son walk around and got arrested. I'm a huge fan of free-range parenting. Not every parent's going to do it. We all have different kind of risk factors and views, but I love the work of Lenore Skenazy with Let Grow. She's done a lot of research on this. They've advanced laws on this. Jonathan Haidt, who's a researcher, he also has done a great deal of work about the importance for kids for letting them do that. So on the reasonable independence for kids, let's do that. On the homeschooling front, there are a very few cases of horrific abuse of children who were ostensibly being homeschooled. Two things on that I want to point out. The first one is all of those cases that I'm aware of, CPS knew about this family. There were attempts in Michigan recently, Illinois, and West Virginia to pass laws basically putting further restrictions on homeschooling because of these. And in all three of those high-profile cases, CPS knew about these families, they had cleared the family, or they were supposed to be checking in, and CPS dropped the ball. So that's the first important thing. And why did CPS drop the ball? It's because of what we've been talking about. 4.4 million cases are coming in. CPS workers are chasing people like Brittany Patterson instead of following up. The West Virginia case is particularly horrific. Instead of following up on a family that they knew about. We have limited resources, limited workers. Let's prioritize this, and I talked about some of those of getting rid of anonymous reporting. But the second point, though, is I want to just read from the 1979 case of Parham versus JR, because when you think about, okay, well, let's put further restrictions on homeschooling because if we can save one child, it's important. Here's what the U.S. Supreme Court said in 1979 in Parham versus JR. Our jurisprudence historically has reflected Western civilization concepts of the family as a unit with broad parental authority over minor children. Our cases have consistently followed that course. Our constitutional system long ago rejected any notion that a child is the mere creature of the state, Pierce versus the Society of Sisters, and on the contrary asserted that parents generally have the right, coupled with the high duty, to recognize and prepare their children for additional obligations. The statist notion that governmental power should supersede parental authority in all cases because some parents abuse and neglect children is repugnant to American tradition. My heart breaks for children who have been harmed. But as the Supreme Court said in 1979, it's a statist notion to say because some people have broke the law, lock them up, throw away the key. Every single parent, like myself, for example, my wife and I homeschool our two kids, we should have to jump through further hoops. Here's further hoops. We think in the First Amendment context, the pen is mightier than the sword. A newspaper can do great damage, but we never require the government to review, prior restraint, what a newspaper publishes. There's defamation laws. There are, laws criminalizing, fomenting abuse, fomenting violence, for example. That's how our system must work if we're to protect our due process, our civil liberties.
I want to just open it up in case anybody else wants to jump in. Okay. All right, so we've got two New Yorkers on the panel, and I know, or my understanding is there's been some significant kind of efforts on the part of parents' rights advocates to enact new legislation. I think it was the anti-harassment and reporting, which would attend to no more anonymous reports, informed consent, family Miranda. But I think all of those have either failed or were vetoed. Is that right? Was there anything? And I guess my question is, what do you attribute that to? I mean, if we're all sitting here and there is a real movement for parents' rights, what happened in New York, and what does that signal for the rest of the country and what's coming?
Well, I think what's happening in New York is that families and communities that have been hurt for so long by child protective services, and the phrase abolition came up, and I just want to say, when I speak to families that are calling for abolition, what they're saying is that this system is doing more harm than good. They're not saying we don't need to protect children. They're saying we're hurting children in the name of protecting children. And those families and communities have really started to rally around different pieces of legislation. One was a very, I think, important change to our registry system in New York. It's extremely easy to put people on these registries where you now have a history of abuse and neglect, typically without having had a hearing first. And now you're banned from all kinds of jobs, and particularly entry-level jobs. So you're made worse off, unable to support your children because the Child Protective Service was involved in your life. This movement of parents' rights activists in New York got our laws changed so that it's far less draconian than it used to be. The other bills you mentioned are still in process, but I'm actually quite hopeful on with respect to all of them. So you mentioned what we call family Miranda. That's telling people their rights. They do this in other jurisdictions already, and I find it puzzling, to put it mildly, how anyone could object to folks knowing their rights. Or let me put it differently. When we don't tell people their rights, what we ensure is that well-resourced families that have access to lawyers know their rights, and under-resourced families don't. There's just simply no way to bring rights to life unless you let people know about them. And so actually a lot of progress has been made on that front. Children's Services in New York City has started in a modest way to let people know more than they did. Those of us who want to ensure people really know their rights are still pushing for the requirement that people more robustly be told their rights. Similarly, with the anti-harassment and reporting bill, this is the bill that would shift from anonymous reporting to confidential reporting, as they have done in Texas. And I want to say, I do think New York is at the forefront in many ways, but Texas, I mean, if you look at the package of family protection laws that were passed in 2023, Texas is on the cutting edge. Again, this left-right coming together, and they've made it much harder for people to make false reports. Informed consent, the other bill that Emily mentioned, is simply a bill that would require hospitals to do what they're already required to do but don't do, which is give people meaningful information before they're drug tested, so that if they have been given drugs during labor and delivery, that doesn't come up as a positive test result that is going to lead to a traumatic investigation. So all of those, I think, are really great examples of state legislation that is moving forward in New York, and that I hope other states will pick up on. But I want to say some of the real challenges of our system have to be dealt with at the federal level. And since we're here in DC, I can't help but hope to call on folks here who are looking, I mean, shifting the perverse financial incentives that we have now to terminate parental rights, and that we are subsidizing the termination of parental rights, and to a tune of $2.6 billion a year going to adoptive families, when many of those kids could be home if we were spending that money on their families. I mean, those are things that need to be dealt with at the federal level.
If I may, Emily, Chris has done just such a wonderful job of advancing this. And I mean, she's a hero in my book. New York and Texas, as she said, have really kind of led the charge on this. But when it comes to telling families of their rights. I was a little intrigued of the law enforcement officer in the last panel. Law enforcement, cops who carry a gun and a badge, they get far more Fourth Amendment training than social workers do. And that shows when a social worker, when an investigator knocks on the door. My boss, the president of HSLDA, Jim Mason, used to lecture at the social worker conventions that, yes, the Fourth Amendment applies to you. He's not been invited back for several years, actually. The Fourth Amendment applies to social workers.
I may have a little bit more of a boring answer to your New York question, which is that in my experience with the legislature in Albany, the influence of your sponsor matters enormously, and who listens to the sponsor of your legislation matters enormously. I also think, practically speaking, and I realize that this is sort of a right-left coming together conversation, but I'll say that in New York, our Democratic governor only won 4 of the 5 counties in New York City, Westchester County and Erie County, which is Buffalo in New York. And I share that because it reflects the relatively conservative New York legislature. Even though they're Democrats, for the most part, in both the Assembly and the Senate, they're not insensitive to the fact that there are those 3 kids under 5 living in a situation that raises real concerns for them about whether New York's children should be living that way. And I agree very much with the change in the law with respect to the state central registry. But I think New York is not as, we are in many ways purple as opposed to blue. The loud city of New York is very, very blue, but as a state, we're not. One thing I want to say about anonymous reporting, I have one concern about eliminating anonymous reporting, and I realize the response might be confidential reporting, but there are not a few victims of sexual abuse in their homes who call the state central registry because they're in the bathroom, they're freaking out, they're worried about their siblings and themselves, and they call anonymously. And I'm sure Chris, I shouldn't speak for her, have had clients. I have had clients, I have kids in the care of my agency who instigated the investigation themselves because they had no place else to turn because their parent wouldn't believe them. And so I think that this is easy to work out in legislation, but I do think that there has to be a considered exception for children themselves reporting anonymously, which makes it much more likely that they will report.
Just real briefly, talk about the red state, blue state divide. And if I'm not mistaken, Texas passed raised the bar, or raised the requirements for removing a child, did the sort of parental Miranda rights, and also entitled families who had been accused of abuse by a child abuse pediatrician, entitled them to an independent review of that. If I'm not mistaken, I believe the Texas Public Policy Foundation, which is a conservative think tank, was behind that. And of course, in Georgia, we actually got rid of the child abuse registry several years ago because we had too many teachers who had run into the convenience store for a second who were substantiated against.
One thing I'd love to just throw out there and hear everyone's thoughts on, I feel like the thing that hasn't really come up front and center in any of the panels to date, and maybe is kind of the elephant in the room, is parental substance use and what the role of the state should be when you have, as Ron described it, what may well be a very sympathetic, well-meaning parent, but who is in the throes of addiction, and a very young child, what doctors should do when they identify prenatal substance exposure. And so I'd love to just hear everyone's thoughts on that, starting wherever. All right, Tom.
I'll throw it out there. Number one, I think parental substance use is a major issue, okay? And I do believe the law should be that if your substance use is not affecting your child, in other words, if you're going out and getting drunk or high on a vacation when your child's with a, appropriate caregiver, that's one thing. I think that that if you think about the substances that are harmful to children, and especially prenatal, alcohol is the biggest one, both prenatal and postnatal. The problem with, as Ron said, we're talking about children who are very young, who are very endangered by active substance use. And there's been kind of a move to sort of act like marijuana is no big deal. I think the problem is that prenatal marijuana use often leads to significant respiratory issues, significant early preterm birth, and actually can be very dangerous. So I think the idea of minimizing, obviously you take everything in consideration, but I think the idea that we're minimizing right now, there's a move to sort of minimize parental substance use is not a big deal, is a dangerous move.
So the science does not indicate that marijuana use during pregnancy leads to significant harms, contrary to alcohol use during pregnancy. And I think, someone said earlier there are range of views on corporal punishment, range of views on marijuana. Anything that there's a reasonable range of views on, those are decisions that should be made by parents and not by the government. But more broadly, to Emily's question, I think everybody in this country understands that we're dealing with a very serious issues of substance use disorder around the country. But again, I want to go to how, the way we should think about how the child welfare system is dealing with it is to look at how do well-resourced families deal with it. And well-resourced families have access to high-quality substance abuse programs that they're engaged in voluntarily and that they get to choose the one that works for them. And their children are not separated from them while they undergo that treatment. And that's the model we should be bringing to every family in the United States. The offer of assistance for those who are struggling with drug use and keeping the mother and the child. Every study shows that if you keep the mother and the child together through that treatment process, they both do better. And that's what our child welfare system should be offering to people.
One thing, just to add to that, completely agree with what Chris said. There also is just a very interesting component of if you're white and wealthy and you're, vaping with marijuana, you're not going to run into any problems. If you're a minority family that might be doing the same thing, yes, you're going to be investigated by Child Protective Services. It really kind of shows exactly, Chris, of what you're saying of if it was good for the goose, it's good for the gander. We've got to stop criminalizing this. I encourage you to look at the work of Shanta Trivedi. I mentioned her already, again, University of Baltimore School of Law. She has a forthcoming paper that's tentatively titled, quote, "The Hidden Pain of Family Policing." And what she talks about is we have to make sure that when we're talking about this whole issue of abuse and neglect, that the cure is not worse than what we're trying to cure, the problem. And when you're coming in and removing children, that's trauma to children, that's going to extend to generations, to families, it's to parents. So we talk about wanting what's best for children. We have got to consider this of when a 6-year-old is being strip searched or is being taken from the home, that's incredible trauma to the children. And I don't think we've thought enough about that in our current system of child welfare.
Yeah, I'll just add that I think that part of what is most interesting about our work and most challenging is that nothing is cut and dry. You can have a parent who is, using a substance in a manner that does not impact their ability to provide a minimum degree of care. And then you have parents, and I'll acknowledge an extreme case, but not one or two, over 4 years on the bench, you have parents in front of you who are nodding off because they are so under the influence, and they have a few kids, under 5, let's say. They could be under 7. And so there are there is a continuum of what is presented to the child welfare system. Obviously, you have to meet the same legal standards before a judge should be able to do stuff to you. But it really is a matter of degree. There are parents who are fine using cannabis, using alcohol, what have you. But at the point where a parent cannot remain attentive in a 20-minute court proceeding, you have to have some concerns for what's going on at home. Things like, is the child being fed? Is the child being changed? Is the front door locked, and are people going to be able to come in and do stuff? So I think it's a matter of degree, and I do think that there's no question that accessibility to good treatment is wanting tremendously in the communities where many of our families come from.
Perfect. Thanks. I think we'll open it up for questions, starting with anybody in the room.
Greetings, I'm Thomas Ward. I've got a case right now to the Supreme Court of the U.S. after it went through the Virginia case. William's aware of it and others. And I sent it to some of the group here. I'm also a member of what's called the Virginia Parents United, which is parents across the country, mainly Virginia, but Texas and everything else. Like there's a great new bill down in Texas that's called, it's about really if you do wrong, you get the time back. And if someone's wrongfully prosecuting, and that's what we're pushing across the country right now. You should also look at, as the two people from New York, back in 2024, there's a very interesting 6-month grand jury looking into CPS and the family services up there. That was an extremely scathing report about the CPS in New York. I don't know if you're aware of that case, but it was a grand jury. The case is about process. It's not about the facts. It's all about the judge's personal opinions. That's really what's going on in these courtrooms. They have nothing to do with the facts. It's a winner and a loser process. They decide who's going to win and who's going to lose, and then who turns around and pays and punishes the one. And on top of it, it's very political. In my case, I had a judge who blatantly says, 1, kids should never go from house to house. 2, you're a political affiliation with X, so therefore you shouldn't see your kids. That should have nothing to do with the cases. Absolutely nothing. And that is what is so wrong with what's going on in our country. Now, you can talk to me, you can talk to, I got a whole group of people who are men, women, teachers, professionals, stay-at-home parents. I was one myself. Democrats, Republicans in the group who are seeing the problem across the spectrum. And the biggest problem is we get focused on parental rights, but we're forgetting about what is the rights of the children. You have to look at cases also when you're talking, what you're talking about is look at cases like Rainey versus Rainey, Bonhoeffman versus Watts, what is telling the courts, you have the action to do to take the activities, not rely on third parties to do this. You got a case like in mine where I asked for an ad litem, they denied it. My kids have never had a right to legal counsel when I was not represented at the time. This is what's going on. If you want further questions, I can explain more.
I just want to say, it is imperfect having human beings as judges. There's no question about it. And people in family court often say, like, what's going on in Part A looks completely different than what's happening in Part C. And obviously, the process by which judges are appointed matters. I also think that it counsels us to make it as difficult as possible to file cases in the family court, and I don't just mean abuse and neglect cases. I think it is an oversubscribed court where people think somehow all their problems are going to be solved by filing a petition, which of course is not the case. I personally think that there's there's been conversation about termination of parental rights cases. Should they exist at all? I think they should be decided by a jury of one's peers. It's about as grave an outcome as you can have in family court, and yet a judge is deciding as opposed to peers. That's very unpopular, an unpopular idea, especially in Bronx County, because people think that Bronx juries are going to always terminate parents' rights when they hear the facts. But I think it's important to be asking questions about how we are engaging in decision-making, for sure. And so, yeah, AI may take over the whole thing, and then we won't need family court judges.
You know, I 100% agree with
One
Ron.
thing you got to understand is,
the Ohio Supreme Court once said famously that a termination of parental rights is to civil law what the death penalty is in criminal law. So 100% agree.
Absolutely.
but I mean, you get cases like mine that are totally written by the attorneys, not even written by the judges. You have in Virginia here, you don't even have to be a clerk of a judge. You don't even have to be barred. You don't even have to have a law degree.
Perfect. All right, I'm gonna.
These are the issues going on.
Thank you. I'm gonna do a question right here. Great, thank you.
Since we have a panel of attorneys, I'm wondering if you've thought through and had any ideas on what standard of proof or review you might propose for these parental rights issues, and would it differ based off of we're talking about termination versus overriding the parent's will on a medical issue or temporary, removing the child, or what may, we have lots of different standards in the law, beyond a reasonable doubt, clear and convincing evidence, preponderance of the evidence. Any thoughts on what standard you might, if you could, either write it into legislation or have it ensconced in case law?
So I'm so glad you asked that because our earlier panels, this question came up: what level of scrutiny, what standards? And I do want to distinguish the world we're talking about now, which is the child welfare world, from some of the topics that were being discussed earlier. It's much more complicated to figure out what the standards are when we're talking about legislation, compulsory education, other majoritarian choices that are being made. When we're talking about child welfare, we are talking about government intervention into the most protected realm, family life. And I don't think there's any question that merits strict scrutiny. It's different when it comes to legislative enactments. But I don't think it's true, as somebody said earlier, some justices on this court might characterize it as a privileges and immunities. They might see it as more Ninth Amendment than substantive due process. But the Supreme Court has over and over again said that parental rights are a fundamental right. And for sure what that means, it's not even a close call, that if you're terminating a fundamental right, that requires strict scrutiny. And what does that translate into? It translates into a compelling interest that's narrowly, and an intervention that's narrowly tailored. Earlier, Tom mentioned what has become, I think, a all too common dichotomy that's set up between safety and terminating parental rights. There is never a situation that terminating somebody's parental rights is required to protect the safety of a child. And that's why once we look at the narrow tailoring that the Constitution requires, we're going to move away from terminating parental rights, because there are other lesser ways to protect children than severing their family ties. And we've done it historically, and we can do it now. So I think as soon as the Supreme Court has a chance to address the substantive piece of parental rights, that they will confirm that it is strict scrutiny. And I'll just say one other thing. That also applies, of course, to family separation. Again, there's no question that there are occasions on which the government does have a right to protect a child if it's a truly compelling danger to the child and removal is necessary to serve that interest. But otherwise, the level at which we're taking kids because of missing school or marijuana use, home in disarray, I mean, those just can't possibly meet the level of constitutional scrutiny that's required.
I'd agree with Chris on the removal. I think, the standard that we kind of technically apply in Georgia and other places is there clear and convincing evidence that there is an imminent risk of immediate harm to the child? Okay. The question, though, you kind of got me a little sideways on is that what does that mean in the overall legislative regulation of parents' rights to do X, Y, and Z? And that kind of takes us back to the last panel with Leor and them. I certainly think that the state doesn't have to show a compelling interest to regulate medication for children, especially when the threat to the child's future is overwhelming. So we talked earlier, I think Marcy talked earlier about the right to an open future. And I think that part of the standard may be what is the impact of this action, whether it's banning a procedure, whether it's requiring certain teaching, whether it's allowing or authorizing or requiring vaccinations. What is the impact of the parental decision on the child's future? And is it something that the child needs to be able to make that decision for himself or herself in the future? Or is it something that if the decision is not made here, the child may very well suffer harm? So.
The only caution I would say to that approach is we cannot, and this is why I 100% agree with what Chris said, that's got to be strict scrutiny because parental rights are a fundamental right. We've got to make sure that we're not saying, okay, well, this parental decision could affect the child's future, so we're going to have government bureaucrats step in, even absent a finding of abuse or neglect. So that would be the only caution I would say, because otherwise then every decision a parent makes, vaccinations, telling their child about religion or bringing them to church could be open to, oh, this could impact the child's future. And we're a pluralistic country. We have very strong views on those things. We've got to trust parents, which is why I'd come back to strict scrutiny on really any impact.
That's a good point.
Yeah, this is a comment and a question for Mr. Estrada. I agree with you that CPS certainly needs better training on Fourth Amendment rights of parents, for sure. That said, in my state, parents have the absolute, just for people who aren't attorneys in here, parents have the right to deny any type of search. They can say, no, I'm not going to do it, you need to leave. Now, if CPS is coercive in that, then that needs to be addressed, right? But I think it's important to point out, they have that right to deny. And I know there's probably conservatives up there. Individual choice is kind of what conservatism is supposed to be about. And I don't see how you can remove that individual choice from the parent and replace it with a government rule. Also, as the comment about never terminating really bothers me, because I've seen offenders who are absolutely going to abuse again. And we just had one sentenced to 60 years because she kept poisoning children, even children not in her care. So for those types of offenders, for sexual offenders who have a compulsion to commit that abuse and are not going to stop, do you still believe that their rights should not be terminated?
So the government is able to take children into protective custody and find safe homes for them without terminating legally that relationship that we all know in reality continues to exist. There is no child for whom their parent is not important going forward, no matter how imperfect that parent is. It may be that that child can never return to that parent. But terminating rights is, I don't know if most folks are aware. I mean, what happens, among other things, with the termination is the government goes in and erases the names on the birth certificate. I mean, that's just an Orwellian step to take. What we can do, and I think the private adoption world has really learned a lot of lessons that haven't been yet absorbed by the public adoption world. What the private adoption world has come to see is that you can't replace a prior family as if they never existed. What you can do is expand the number of adults with whom a child has meaningful relationships. And maybe the child, in the extreme, very rare cases you're talking about, maybe the child doesn't even see the parent. Most of the time, having as much contact as is possible while that parent is dealing with a substance use issue or a mental health issue. Generally, the more contact, the better for the child as well as the parent. But it's a legal fiction, the terminating parental rights, and it's not benefiting anyone. We can transfer whatever rights we need to transfer in order to protect the child. Custody rights can be transferred, medical decision-making rights, but there's no reason to cut them off. There's no other fundamental right that we entirely cut off that way, and I truly believe it's the kind of thing, we're going to look back and really wonder how our society was able to do that.
There are times, I think, Chris, when the parent themselves does not wish to have continued contact with their biological child. And I wonder how you would enforce the kid's interest in a relationship with the parent that is declining to be interested.
So I, of course, think it's quite rare for a parent not to want to.
It is very rare, but in the private adoption world, it's a little less rare because sometimes the parent surrenders and actually expresses that they do not want to have further contact.
Right, but of course, what's key in the private realm is that it is a voluntary choice by the parent. The idea that the government is saying we're over your objection, we're severing your relationship, makes it a very different situation. And I do think that even parents who, for whatever reasons, may go through a period where they don't believe it's in their child's best interest to have contact, most often that's a period that ends and later they do. Many kids reconnect later. But I think what's key about your question, Ron, is that at the end of the day, it is about creating options for children, leaving open the option to reconnect. And most kids are going to want to have that one. And that's why transferring certain rights and not extinguishing rights, not saying we're forever banishing someone from someone's life, that's just an unnecessary step to take. And I do want to say that it has also been empirically shown that guardianships create just as much permanency for children without cutting them off from their parents, from their siblings, from their extended family. And so we need to move in that direction of guardianships rather than terminating.
All right, I'm going to let Tom get the last word in here, and then...
I think the valid point you make is that regardless of what you call it, we have to consider the child's right to be with people the child loves and cares for. In other words, it's the child's attachments. They're important. So if that is best accomplished by giving guardianship to a foster family and just not severing the rights, but just kind of seeing what happens in the future, if there is a real danger that the parent might come back into the picture and harm the child, that's a different issue. But I do think that it's not just simply a parent's rights, terminate, don't terminate. It's a child's attachments versus the child's need for family.
Perfect way to close. Please join me in thanking our panelists.